ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Get it off of me. Get it off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?
Guys, the verdict is in. Motions are in. Rhoda, Tanya, where you guys at? A lot of reading. She got a lot of pages, y'all. She has a lot of pages. One has 65 pages, 63. The other one has a lot of pages, just a lot of pages. One has, okay, that one has 2 pages. She has one asking for a new trial and the other one for acquittal. Okay. Lot of pages. Boy, she got so much stuff in here. Hold on a second. I'm just waiting for prospective me and Rhoda. about to send it to you. No, I have it. It came in at 8:40. Oh, okay, sorry. It came in at 8:46. Hold on a second, Perspective. I'm about to send it to you, okay? Right at Perspective. Yes, a lot of pages, a lot of pages. A lot of pages. One is 22 page, then it's 2 page and 63, and 63 and 2 comes out to 65. Yeah, 24. He's not playing. He is not playing. One is for motion for acquittal. The other one is motion for new trial. And you got the other thing?
No, don't chase me.
You got it?
Hello.
You got it?
Let me lock my door. My baby about to chase me. I'm up, but mommy is about to do something.
Lord, give me strength.
Hey, can you hear me?
Yeah, I can hear you.
I don't know why it's so low.
One of them I sent twice.
Okay, let me see.
Let's do the first. Do the acquittal one first.
Okay, hold on 1 second. Jaden, go downstairs with Dad. I'll be out in a second.
Hey, far from average. Hello, guys. Rhoda, are you coming in?
Yeah. Okay, which one did you want me to go to first?
Do the one that says motion. That's the acquittal.
Okay.
Hold on a second. I gotta open up. Alright, I think I got mine already. Oh, wait. The acquittal. Let me see which one goes first. The one that goes first is the acquittal. Go read the one that says acquittal. That's
Okay.
the one that goes first.
Okay. Jennifer Bonjean, an attorney at law, certifies that I filed defendant's notice of a motion for a judgment of acquittal and memorandum of law in support of the motion via ECF on February 17th, 1922. Let me scroll down. Okay, so I'm going to go all the way down past the table of contents, you guys. Hold on. I'm starting with the instructions. Sylvia? Okay. In Fitzgerald versus Chrysler, Chief Judge Posner cautioned that where a statute is broadly worded in order to prevent loopholes from being drilled in, it is ingenious lawyers. There is a danger of it being applied to situations absurdly remote from the concerns of the statute's framers. Such is the case here, where the government misused both the Racketeer, Influence, and Corrupt Organization statute and the Mann Act in a manner never previously perceived or carried out. Invigorated by an influential social movement determined to punish centuries of men misbehavior through symbolic prosecutions of high-profile men, the government brought a RICO prosecution against the defendant that was...
Perspective. Sorry.
Okay.
You're supposed to be reading the introduction.
I am reading the instructions.
No introduction.
Oh, I am reading the introduction. I'm sorry. You wanted me to go back and read something else? I'm sorry.
I want you to read the introduction right after the table of contents. Did you read the introduction?
I am.
What you have in acquittal one, right?
The one that just said motion is the one that I opened.
No, the acquittal. That was the first one. The acquittal.
Okay, hold on. Let me see what this says at the top.
That's the same thing I'm reading. Okay.
I believe it does say that right at the top, acquittal, but let me scroll up. It says Defendant Robert Kelly's memorandum of law in support of a judgment of acquittal.
That's it. That's the one. Yeah.
Okay, so I'm going to go back down.
That one went first before the other one.
Okay. I was asleep. I woke up and jumped on. Okay, I'm sorry about that. So invigorated by an influential social movement determined to punish centuries of male misbehavior through symbolic prosecution, a high-profile man, the government brought a RICO prosecution against the defendant that was absurdly remote from the drafters' intent, stretching the liberal construction clause well beyond the intent of Congress. The government constructed a RICO theory of prosecution designed.
So sorry, but what are you reading? Are you reading numbers 270?
I am reading page 1.
No, what's the numbers of the document? Is it 270?
Document 269-1.
Okay. Go ahead, I'm sorry.
Okay. Lost my place. The RICO statute defendant. The government constructed a RICO theory of prosecutions designed not to infatuate the purpose of the RICO statute, but to prosecute the defendant for alleged misdeeds going back decades without pesky statutes of limitation obstacles. Adding to its history of Celebrity Mann Act prosecution, the government extended the broad language of the Mann Act to conduct it never intended to remedy. While the Mann Act may be an effective tool for combating human trafficking, it was not designed to punish sexual misconduct like that alleged against defendant, where defendants alleged transportation of females, largely consenting adults, was incidental to his travels as a world-renowned performer. He is now not guilty of the Mann Act violation. If the government intends to prosecute Mann Act violations in the fashion it did here, it might consider investigating the many influential, wealthy, mostly white corporate leaders who frequently arrange travel for Paramars. I'm not sure what Paramars is, who later conclude that the experience was less than pleasant. Okay, go. A detached and unemotional review of the evidence in this case shows that the government presented an overabundance of bad character evidence to compensate for its insufficient proofs of the specific elements of RICO in the Mann Act. Accordingly, this court must acquit defendant of the verdicts of guilt entered against him. Relevant facts. The government charged defendant with one count of racketeering based on 14 predicate acts, and 8 standalone counts of violations of the Mann Act that were also charged as racketeering acts, which, with the exception of Racketeering Act 1, alleging the offense of bribery, the charged offenses involved conduct alleged by 5 women, Jahonda, Jane Doe number 4, Jane Doe number 5, Jane Doe number 2, Jane Doe number 3, Jane Doe number 6. The jury returned a verdict convicting defendant of all charge counts, but acquitted him of those racketeering acts related to Sonia. Given the length of the record, defendant will incorporate relevant facts into the argument sections as appropriate. Okay, argument. This court must set aside the verdict of guilt entered against the defendant and enter a judgment of acquittal where the government presented insufficient evidence of the offense of racketeering, count 1, and all Mann Act violations, counts 2 through 9. Federal Rule of Criminal Procedure provides that if the jury has returned a guilty verdict, the court may set aside the verdict and enter an acquittal. A court can enter a judgment of acquittal on the grounds of insufficient evidence only if, after reviewing the evidence in the light most favorable to the prosecution and drawing all reasonable inferences in the government's favor, it concludes no rational tier of fact could have found the defendant guilty beyond a reasonable doubt. To sustain a conviction, the jury must have been able to find each of the essential elements of the crime beyond a reasonable doubt. As set out in detail below, defendant's RICO conviction cannot stand where the government failed to prove the existence of an enterprise, the activities of which affected interstate commerce and a pattern of racketeering activity. Moreover, insufficient evidence existed to prove each and every element of the charged Mann Act violations by proof beyond a reasonable doubt. Okay. The government failed to prove defendants guilty of the offense of racketeering, count 1. This court must acquit defendant of the offense of racketeering where the government failed to prove defendant guilty beyond a reasonable doubt of each and every element of the offense. The government effectively swapped the jury with bad character evidence that was guaranteed to produce a guilty verdict, but its proof on the charged offenses were insufficient as a matter of law. Ignoring the distinctly economic legislative history of the RICO statute, the government brought a RICO prosecution against the defendant, not to remedy widespread criminal activity of an enterprise, but to punish one man whose alleged crimes could no longer be prosecuted by state and local agencies. The government's belated interest in protecting defendants' alleged victims does not justify application of the RICO statute to allege private sexual misconduct of the defendant and only the defendant, even if some of this conduct could have been timely prosecuted by the local authorities long ago. As a reminder, RICO's primary purpose was to combat organized crime by prosecuting the highly diversified acts of a single organized crime enterprise under a RICO umbrella. The overreaching goal of this statute was to curb the infiltration of legitimate business. The overreaching goal of this statute. I'm going to read it.
Down.
Huh?
I hear Rhoda's thing in the background.
Let me put my phone on do not disturb so no one can call too. Hold on one second.
Thing in the background.
Let me put my phone on do not disturb so no one can call too. Hold on one second. Okay. Let me put my phone on Okay, you ready?
Yes, ma'am.
So I'm gonna read that last sentence again. The the overarching goal of the statute was to curb the infiltration of legitimate business organizations by racketeers. In its statement of finding and purpose accompanying the RICO statute, Congress declared the following. Congress finds that, number one, organized crimes in the United States is a highly sophisticated, diversified, and widespread activity that annually drains billions of dollars from America's economy by unlawful conduct and the illegal use of force, fraud, and corruption. Two, organized crime derives of major portions of its power through money obtained from such illegal endeavors and syndicated gambling, loan sharking, the theft and fencing of property, the importation and distribution of narcotics and dangerous drugs, and other forms of social exploitation. This money and power are increasingly used to infiltrate and corrupt legitimate business and labor unions and to subvert and corrupt our democratic process. Number four, I'm sorry, that was number three. Number four, organized crime activities in the United States weakened the stability of the nation's economic system, harm innocent investors and competing organizations, interferes with free competition, seriously burdens the interstate and foreign commerce, threaten the domestic security, and undermine the general welfare of the nation and its citizens. And five, organized crime continues to grow because of defeats in the evidence gathering process of the law, in inhibiting the development of the legally admissible evidence necessary to bring criminal, other sanctions, or remedies to bear the unlawful activities of those engaged in organized crime. And because the sanctions and remedies available to the government are unnecessarily limited in scope and impact. It is the purpose of this act to seek the eradication of organized crime in the United States by strengthening the legal tools and the evidence gathering process, by establishing new penal prohibi- pro- ah, prohibitions, prohibitions, and by providing enhanced sanctions and new remedies to deal with the unlawful activities of those engaged in organized crime. Organized Crime Control Act of 1970. Admittedly, prosecutors have used RICO in a wide variety of circumstances under the statute's liberal construction clause. The liberal construction clause, notwithstanding, the Supreme Court has acknowledged that the clause is not without limits. As the court held in Revis, the liberal construction clause was not an invitation to apply RICO to new purposes that Congress never intended. The government clearly exceeded those limits with this prosecution, as evident by its failure to prove the charged offense of racketeering. Okay. To sustain a conviction for RICO, the government must prove that the defendant, one, through the commission of two or more acts constituting a pattern of racketeering activity, two, directly and indirectly invested in, maintained an interest in, and or participated in an enterprise, three, the activities of which affected interstate or foreign commerce. As set out below, the government offered insufficient proof of all elements of the offense of racketeering. A, the government's proof did not establish an enterprise. Okay. The government's case was doomed from the start, where it failed to plead and prove an enterprise. An enterprise includes any individual, partnership, corporation, association, or other legal entity in any union or group of individuals associated. In fact, although not a legal entity, the United States Supreme Court has defined a RICO enterprise as a group of persons associated together for a common purpose of engaging in a course of conduct. An enterprise is demonstrated by evidence of an ongoing organization, formal or informal, and by evidence that the various associates function as a continuing unit. First Capital Asset Manager versus Satinwood. Okay, for an associate of individuals to constitute an enterprise, the individual must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. The enterprise's purpose must be common to all of its members. Stein versus World Plumbing Supply. Let's get down. The enterprise is neither the individual defendant nor the pattern of the racketeering activity. Rather, it is an entity separate and apart from the pattern of activity in which it is engaged and must be alleged and proved separately. However, there must be a nexus between the enterprise and the racketeering activity that is being conducted. United States versus Indelicato. Furthermore, the RICO enterprise must have an ascertainable structure separate and distinct from the pattern of racketeering activities. And that's another case. Finally, for 1962 purposes, the person charged with a RICO violation and the alleged enterprise must be separate and distinct from one another. This requirement flows from the statutory mandate that a person who engaged in a pattern of racketeering activity must be employed by or associated with the enterprise. An entity cannot simultaneously be the enterprise and the person who conducts its affairs. Permitting that would be a tantamount to tantamount. TANTA mount. Tantamount to permitting an entity to associate with itself. Okay, common purpose. In its third superseding indictment, the government alleged that the defendant, his employees, his managers, bodyguards, drivers, personal assistants, and runners, and other members of his entourage constituted the enterprise for RICO purposes. According to the government, the purpose of the enterprise was to 1. Promote the defendant's music and his brand. 2. Recruit women and girls to engage in illegal sexual activity with the defendant. 3. Produce pornography, including child pornography. The government did not allege that the enterprise constituted a legal entity, but rather an association of individuals. Superseding indictment. As held in Satinwood Supra, for an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent course of conduct to work together to achieve such purposes. Thus, for the government to establish an enterprise here, it was required to prove that the defendant, his employees, and his entourage came together with a common purpose of recruiting women and girls to engage in illegal sexual activity and produce pornography, not merely the broader purpose of promoting defendant's music or band. Assuming the defendant's employees and entourage did share a common objective of promoting the defendant's music, the objective had no nexus to the underlying racketeering activity. Defendant did not go through all the trouble of becoming a world-famous R&B singer for the purpose of engaging in illegal sexual activity. Even if his job put him in a proximity to women, the government cannot end run the common purpose required by identifying a broad objective of the enterprise, unrelated to any fraudulent act to the racketeering activity. The government's evidence of an enterprise was insufficient because it failed to establish the defendant's employees and entourage shared a common purpose of recruiting women to engage in illegal sexual activity with the defendant that included creating pornography. Notably, the government does not define illegal sexual activity, but based on the predicate acts charged, the government contends that the defendant's employees and entourage shared an objective of ensuring that the defendant had his sexual needs met by women, some but not all underage women, while at home and while traveling, was able to control these women to engage in sexual conduct. The government deemed abusive was able to videotape his sexual activities with these women and could expose his sexual partners to herpes. To be clear, the government contends
What page are you on?
that was 7, and I'm at the top of 8.
Okay, thank you.
Okay. To be clear, the government contends that making sure the defendant's sexual needs were met was the objective of the enterprise, in addition to promoting his music and brand. Conceitedly, the government offered evidence that the defendant's various employees carried out some tasks that related to connecting the defendant to women, which whom he had a personal, even sexual relationship, or with a woman whom he was interested in having a sexual relationship. These tasks included providing the defendant's phone number to women who attended his concerts, inviting women to after parties, arranging for travel for defendant female guests, and ordering food for those guests while they visited his property. However, the record is devoid of evidence that the members of the enterprise acted with the common objective of ensuring that defendant engaged in illegal sexual activity. It is true that RICO does not have a mens rea, REA, requirement beyond what is necessary for proving the predicate crimes. But where the government's evidence of the enterprise centers on its claim that the associated in fact members shared a common purpose of ensuring defendants' illegal sexual activities, the government must offer some evidence that the members of the enterprise knew that their actions were promoting not just legal sexual activities, but illegal sexual activities and the production of pornography. Put in terms expressed in satin wood, the government was required to show that the individual who made up the enterprise shared a common purpose to engage in a fraudulent course of conduct. To share a purpose requires the member to agree on what that purpose is. Defendant is not claiming that each member of the enterprise must have possessed knowledge about every predicate act that the defendant is alleged to have committed, but the government cannot prove a common purpose without showing that the members of the enterprise shared an understanding of what that purpose was, which according to the government was promoting illegal sexual activity and producing pornography. Despite its bullying tactics, the government came up short on evidence that all the defendant's employees who made up this vague enterprise were working as a continuing unit to ensure defendant could engage not just in sex, but illegal sex. No employee testified that he or she understood that their purpose in the enterprise was to recruit underage women, nor did any member of the enterprise present any testimony that they had any knowledge that the defendant's herpes diagnosis, that he practiced unsafe sex, or that he videotaped his sexual experiences. The government can point to no evidence that any employee possessed specific information about what precisely transpired in the defendant's bedroom once he was alone with his female guests. Even if the defendant's employees knew that the defendant expected his guests to follow strict, even controlling rules and possessed recording devices like iPads and iPhones, it does not follow that the members of the enterprise shared a goal of promoting illegal sexual activity. Enterprise distinct from racketeering activity. To the extent the government argues that its evidence showed that the member of the enterprise shared a common purpose and had acknowledged had knowledge of promoting the defendant's illegal sexual conduct, The government has failed to demonstrate that the purpose of the enterprise was distinct from the racketeering activity. Separately, the government was required to demonstrate that the defendant was distinct from the enterprise. It is axiomatic that clearly envisions that the person in the enterprise will be distinct. Bennett 770F. This requirement focuses the section on the culpable party and recognizes that the enterprise itself is often a passive instrument or victim of the racketeering activity. The United States Supreme Court has held that the RICO defendant must have participated in the conduct of the enterprise's affairs, not just his own affairs. The government cannot plead its way around the distinctness requirements by simply alleging that the enterprise is defendant's inner circle and introduce a series of headshots of all the defendant's former employees as evidence of an enterprise. The enterprise, as alleged by the government, existed because of its goal to promote the defendant in his legal and alleged illegal sexual activities. It had no function unrelated to the defendant. Under this factual pattern, the distinctness requirement was not satisfied. Because the government's RICO prosecution under this fact pattern is entirely unique, there is a dearth of factually analogous analogous authority on this issue. That said, guidance offered in factually dissimilar cases leads to the clear conclusion that the government failed to prove an enterprise distinct from the defendant. In Riverwood Supra, the plaintiff Riverwoods Corporation claimed that through acts of extortion and mail fraud, the defendant, Marine Midland Bank, coerced Riverwood to restructure loan agreements between Riverwoods and Westchester Federal Savings, later acquired by Marine Midland. Riverwoods purchased a property in Newcastle, New York, to develop residential condominiums and obtained a loan from Westchester Federal Savings, made a for that purpose. Marine Midland later acquired Westchester Federal Savings and inherited the loan agreement. According to Riverwood, shortly after the acquisition, Marine Midland officers made it clear that they intended to dishonor the existing agreement and that they engaged in extortive behavior to force Riverwoods to enter into a new loan agreement with terms more favorable to Marine Midland. In its complaint, Riverwood alleges inter alia, ALIA, that through a pattern of racketeering activity, Marine Midland and two of its loan officers participated in the affairs of an association, in fact, enterprise known as the Restructuring Group. In violation, the Second Circuit reiterated that under the plain language of the statute, the RICO person must conduct the affairs of the RICO enterprise through a pattern of racketeering, and that the person and the enterprise referred to must be distinct. The court emphasized that a corporate entity may not be both the RICO person and the RICO enterprise, acknowledging that the distinctness requirement could be satisfied where there is partial overlap between the RICO person and the RICO enterprise, and that a defendant may be a RICO person and one of a number of members of the RICO enterprise. However, by alleging a RICO enterprise that consists merely of a corporate defendant associated with its own employees or agents carrying on the regular affairs of the defendant, the distinctness requirement may not be circumvented. Finding the that the Riverwood had failed to prove the distinctness requirement, the Riverwood court observed that because a corporation can only function through its employees and agents, any act of the corporation can be viewed as an act of such an enterprise, and that the enterprise is in reality no more than the defendant itself. Where employees of the corporation associate together to commit a pattern of a predicate act in the course of their employment and on the behalf of a corporation, the employees in the association with the corporation do not form an enterprise distinct from the corporation. The Riverwood court scoffed at the notion that the plaintiff seriously contended that the actions of the restructuring group were anything other than the activities of Marine Midland employees carrying out the business of that bank. The court reasoned both the allegations in the complaint and the proof at the trial showed that the individual members of the restructuring group were employed by Marine Midland at the relevant times. Those employees were acting within the scope of their authority as officers of Marine Midland, and all of the actions taken by the restructuring group, such as the negotiating and execution, the restructured loan, and the exacting personal guarantees from Shapiro, were undertaken on behalf of Marine Midland and were directly related to the bank's business. The Second Circuit reached a similar conclusion in Discon versus 9X Corp. Their Discon Inc. was a New York corporation whose primary business was to provide removal services to telephone companies. Discon argued that the defendant Nexness, a holding company that controlled subsidiaries, conspired with AT&T Technology to eliminate Discon from the market removal services by defrauding the public. Discon sued the Nexus defendants for civil RICO, alleging that the Nexus Group, which consists of Nexus, IMCO, and Nextel, were three separate corporate persons that conducted the affair of the Nexus Group enterprise through a number of illegal predicate acts. The Second Circuit observed that the distinctiveness requirement could not be circumvented by alleging a RICO enterprise that consists merely of a corporate defendant associated with its own employees or agents carrying on the regular affairs of the defendants. Relying on Riverwoods, the Second Circuit stated that where employees of a corporation associate together to commit a pattern of predicate acts in the course of their employment and on behalf of the corporation, the employees associated with the corporations do not form an enterprise distinct from the corporation. The court observed that, like the defendants in Riverwood, Nexus, IMCO, and Nextel operated within a unified corporate structure, and even though they were legally separate entities, the relationship between Nexnix, Miko, and Nextel was not substantially different from that between the loan officers and Riverwood in comparison to the bank. In both cases, the individual defendants were acting within the scope of single corporate structure, guided by a single corporate consciousness. Finding no enterprise distinct from the person where the defendant bank, its holding companies, and three employees were not associated in any manner apart from the activities of the bank. Applying the rules of the foregoing cases, the government failed to prove an enterprise distinct from the defendant by alleging a RICO enterprise that consists of defendant and his own employees, agents carrying on his affairs, namely promoting his brand, his music, and his sexual needs. The government fails to satisfy the distinctness requirement. Put differently, because the government alleged that the defendant's employees associated together for no purpose other than to carry out defendant's needs, including his illegal sexual activity, the employees did not form an enterprise distinct from the defendant. Defendant and the alleged enterprise were one and the same. To sustain a conviction for racketeering, the government must offer proof beyond a reasonable doubt that the alleged racketeering activity affected interstate commerce. Section 1962C declares that it is illegal for any person employed by or associated with any enterprise engaged in or the activities of which affect interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises affairs through a pattern of racketeering activity. This provision anchors the Act to Article 1 congressional power by incorporating and affecting interstate commerce requirements. The United States Supreme Court has determined that an enterprise is engaged in commerce when it is directly engaged in the production, distribution, and acquisition of goods and services in interstate commerce. However, consistent with the liberal construction clause of the Rico Act, some courts have held that the racketeering activity of the enterprise needs only have a de minimum effect on interstate commerce. This court instructed this jury, consistent with the view that the government needs only prove that beyond a reasonable doubt that the enterprise had a minimal effect on interstate commerce. This court further instructed the jury that it is not necessary for the government to prove that the individual racketeering acts themselves affected interstate or foreign commerce. Rather, it is the enterprise and its activities considered in their entity that must be shown to have had that effect. No source was provided for this specific statement of law. Oh, sorry, readjusting. Assuming the government was only required to prove that the enterprise had a de minimis effect on the interstate commerce, the government failed to establish that element by proof beyond a reasonable doubt. Because the existence of the enterprise in this case hinged on the specific activity of promoting defendant's illegal sexual activity rather than promoting his music, the government was required to prove that those racketeering acts affected interstate commerce. Courts have held that to satisfy RICO, only the enterprise and not the predicate acts themselves must affect interstate commerce. However, that is only where there a nexus between the objective of the enterprise and the charged racketeering activities. While the government may and did argue that the defendant's activities centered around promoting and performing his music affected interstate commerce, the charged racketeering acts are untethered to those activities. The government cannot end run the affecting commerce requirement by claiming an economic purpose of the enterprise that has no connection to the charged racketeering activity. The government's ability to prove an enterprise turns on its claim that the purpose of the enterprise was to promote defendant's illegal sexual activity and create pornography for his own personal. Thus, the government does have to prove that those activities affected interstate commerce. Defendants' alleged conduct of engaging in sexual activity with young women under the age of 18, exposing adult women to herpes, and or videotaping his sexual activities with individuals under the age of 18 cannot be said to have any impact on interstate commerce. Indeed, the de minimis effect approach here amounts to an unconstitutional extension of commerce powers and is contrary to RICO's distinctly economic legislative history. It is beyond debate that the legislative history and the congressional findings accompanying the act reflect Congress's prevailing concern with a negative economic impact of criminal infiltration into legitimate businesses. Some scholars have argued that eradicating criminal infiltration of legitimate business activities was the act's only purpose. Admittedly, the Supreme Court in Turk sanctioned the application of RICO to non-infiltrations when it held that a RICO enterprise may be a wholly illegitimate organization. Scholars have observed that Turkey marked an expansion in RICO prosecution. Who is all these names? D'Angelo Frank note turf wars, street gangs, and other outer limits of RICO's affecting commerce requirement 46 Fordham. The first wave of expansion extended RICO in the areas of government and corporate corruption. During the 1980s, federal prosecutors used RICO to prosecute corrupt corporate officers, state officials, and judges. A second wave saw prosecutors use RICO to prosecute violent gangs. Until the late 1980s, murder was rarely prosecuted in federal court, but since the federal prosecutors have used RICO to bring down murderous motorcycle gangs, white supremacist groups, and ethnic street gangs. As D'Angelo points out, in most of these types of cases, RICO commerce requirements was easily satisfied. In all of those scenarios, an economic motive was driving the racketeering activities. In contrast here, the alleged enterprise in this case had the objective of ensuring that defendants' sexual desires were satisfied. There was no economic motive driving these activities.
Do you want to take a break and let Rhoda take over?
Rhoda, do you know where we are?
Rhoda, you there?
Yeah, I was trying to unmute. I'm sorry. Yeah, I'm right where you are.
You can go if you.
Okay.
You can go.
Okay. The government's proof did not establish a pattern of racketeering. The government must also demonstrate a pattern of racketeering activity by proving, at a minimum, 2 predicate racketeering acts that occurred within 10 years of one another. Proof of 2 predicate acts is not sufficient to satisfy its burden of proof. The government must also show that the racketeering acts are related to each other and to the enterprise, and together pose a threat of continuing criminal activity. Predicate acts must bear a relationship to each other that manifests the continuity required to prove a pattern. RICO is inapplicable to perpetrators of isolated or sporadic criminal acts. Criminal conduct only forms a pattern if it embraces criminal acts that are related. Focusing on the relatedness requirement, the predicate crimes must be related both to each other, termed horizontal relatedness, and to the enterprise as a whole, termed vertical relatedness. Horizontal relatedness can be shown through predicate acts that have the same or similar purpose, results, participants, victims, or methods of commission, or otherwise are interrelated by distinguishing characteristics and are not isolated events. Where the enterprise in question is not primarily in the business of racketeering activity, predicate acts must be related to each other in kind for a RICO case to proceed. Vertical relatedness requires only that the defendant was enabled to commit the offense solely because of his position in the enterprise, of his involvement in or control over the enterprise's affairs, or because the offense related to the activities of the enterprise. With regard to continuity requirement, the government must present evidence regarding the timing and temporal scope of the alleged racketeering acts to demonstrate either closed or open-ended continuity. Criminal activity that occurred over a long period of time in the past has closed-ended continuity, regardless of whether it may extend not the future. Close-ended continuity is primarily a temporal concept that requires that the predicate crimes extend over a substantial period of time. In contrast, criminal activity that by its nature projects into the future with the threat of repetition possesses open-ended continuity, and that can be established in several ways. Some crimes may be, by their very nature, of future threats. When the business of an enterprise is primarily unlawful, the continuity of the enterprise itself projects criminal activity into the future. Similarly, criminal activity is continuous when the predicate acts were the regular way of operating that business, even if the business itself is primarily lawful. The government failed to demonstrate a pattern of racketeering activity because it offered insufficient evidence of most of the predicate acts, and the charged acts lacked sufficient relatedness and continuity. Racketeering Act 1, Bribery. The government failed to prove Racketeering Act 1, where insufficient evidence existed to prove that the defendant caused Demetrius Smith to pay a public aid employee $500 to secure identification for Jane Doe number 1. Despite blatant strong arming by the government, Smith's testimony was inconsistent and vague about whether the defendant was even present during any discussions about paying money to bribe someone for the fraudulent identification. Smith consistently testified that he discussed the prospect of bribing someone to obtain the fake identification with Darrell McDavid. Smith did not obtain any money from the defendant and did not recall discussing it with him, although he allowed that he might have. Whenever Smith failed to testify precisely as the government wanted, he was refreshed with his prior statements, not because he needed refreshing, but as a clear reminder that if he contradicted himself, he could be charged as a co-conspirator. That type of bullying pervaded Smith's examination and suggested that Smith's testimony may have been pressured by the government. After the subject matter had been discussed numerous times throughout Smith's testimony, the AUSA asked the following on redirect. When you spoke to the group as you testified on direct examination, when you spoke to the group about acquiring a state ID from the welfare office, Jane Doe number 1 for money, the defendant was there, right? I'm pretty sure. I think so, but I'm not. I'm just not positive. Even if I said it before, I'm just not positive. I just don't see that in my head right now. Not satisfied with that answer, the AUSA asked Smith again whether the defendant was present when there was any discussion about a bribery. Despite his clear concern of facing legal repercussions for his testimony, Smith declared, I don't remember if Robert was there. If I said he was there before, I'm not changing that story to change the story. I'm just going back and I'm just trying. I don't see it in my head, Robert next to me. No rational jury could conclude that this less than convincing testimony provided proof beyond a reasonable doubt that defendant caused Smith to tender money to the public aid officer. Even if the evidence showed that the defendant turned to Smith for assistance in facilitating his marriage to Jane Doe number 1, the offense of bribery requires proof that the defendant at least knew of Smith's intent to bribe a public official and facilitated in the bribery in some way. The record is devoid of evidence that defendant knew how Smith obtained the identification or facilitated Smith in obtaining the identification. As far as defendant knew, Smith obtained the identification from a friend who worked in the public aid office. Without Smith's unequivocal testimony that defendant was part of the planning process of obtaining the fraudulent identification, the evidence was insufficient to sustain the bribery offense. Furthermore, Racketeering Act 1, bribery, lacks both vertical and horizontal relatedness. It was an isolated offense having no connection to the other charged acts or to the purpose of the enterprise itself. Indeed, as discussed supra, the record simply fails to show that in 1994, any enterprise existed that had a common purpose of facilitating defendant's sexual desire for minors. Smith testified at length that he had no idea that the defendant was involved in any type of sexual relationship with Jane Doe number 1 or any other young women. Smith was certainly part of defendant's close circle of confidants, but the mere identification of a group of people who work for the defendant does not an enterprise make. Smith did not testify about any other conduct in which he engaged to advance the alleged purpose of the enterprise. Smith's conduct was nothing more than a singular event that bore no connection to the purpose of the enterprise, which did not exist in any event, and which bears no connection to the other Racketeering Act. Furthermore, because the act did not occur within 10 years of any other predicate act that was sufficiently proven, the act is time barred. Racketeering Act 1 was not proved beyond a reasonable doubt. Racketeering Act 2, sexual exploitation of a child. Stephanie. I don't know which day know she was. The government failed to prove Racketeering Act 2, that is, sexual exploitation of Stephanie, where it offered insufficient evidence that defendant used, employed, persuaded, induced, or enticed Stephanie to take part in sexually explicit conduct for the purpose of producing a visual depiction. The government contends that on a single occasion, prior to her 18th birthday, defendant had sexual relations with Stephanie at his studio in Chicago, Illinois, and recorded the episode on a video camera. The government cannot produce the video or the camera on which it was allegedly recorded. To be clear, the defendant is alleged to have recorded a legal and seemingly consensual act under the law of the state of Illinois that was only a violation of 18 U.S.C. 2251, paren A, because Stephanie was not 18 years of age. To demonstrate that defendant committed sexual exploitation of a child pursuant to 18 U.S.C. 2251, paren A, it is not enough for Stephanie to simply allege that defendant recorded sexually explicit conduct. Stephanie offered no testimony that proved that the defendant used, persuaded, induced, enticed, coerced her into sexually explicit conduct. Stephanie had an ongoing sexual relationship with the defendant before the video recording incident and after the video recorded incident. Although she described those sexual experiences in hindsight as humiliating, it does not follow that the defendant did anything to persuade, induce, entice, or coerce her into sexual activity that was recorded. In fact, Stephanie admits that the defendant called her on the phone and told her that he was picking her up and that he wanted to make a video of us having sex and that he would be there shortly. To which Stephanie responded, okay. Although Stephanie clearly regrets this decision, her own testimony shows that the defendant did nothing, okay, but tell her he wanted to video them having sex and she agreed. The government must prove that the defendant did something more than just film the sexually explicit conduct. If the act of filming or recording alone was sufficient to sustain the charge, Congress would not have included a requirement that the defendant employ,
You're starting to get an echo.
Induce, entire, or coerce. What you say?
You're starting to get an echo. You gotta go down to the mic and take your echo off.
Okay, how do I do that? What about now? Because I don't have anything else on. Is it
So
still
when you go down to the settings where it says cam/mic, click that, and inside of there it'll say
I don't
audio.
hear echo from her.
I don't either. I don't have anything on. I don't
hear echo.
Okay.
Echo cancellation. Just uncheck that.
Yep, that did it.
Okay. I mean, I don't hear echo, but okay, I did it. Okay, let's see. Furthermore, the government failed to prove that the defendant acted with the purpose of producing a visual depiction of that conduct. Although the jury was erroneously charged that the government could sustain the charge by proving that the purpose was transmitting a visual depiction. The statute requires something different. Indeed, producing is defined by the statute as producing, directing, manufacturing, issuing, publishing, or advertising. While the statute also prohibits the transmission of live visual depictions, defendant was not charged with transmitting a live visual depiction, and there is no evidence that he did. Lastly, the parties' stipulation that the film used in VHS tapes was a type of film that was not produced in Illinois is insufficient to prove by a reasonable doubt that the conduct was recorded on a device made in a foreign country or affected interstate commerce. Accordingly, the government failed to prove Racketeering Act 2 by proof beyond a reasonable doubt. Racketeering Act 5, Mann Act violation, Juror. The government failed to prove Racketeering Act 5 where there was insufficient evidence that defendant, number one, used the facility of interstate commerce to knowingly persuade, induce, entice, coerce Juror to engage in sexual activity that violated Illinois law, and that number two, defendant knowingly committed the prohibited sexual activity. To obtain a conviction under 2422 (b), the government must show that the defendant used the facility of interstate commerce to knowingly persuade, induce, or entice any individual who is younger than 18 years of old to engage in sexual activity of a criminal nature. United States versus Brand. First, the government did not prove that the defendant used the facility of interstate commerce to persuade Juror to engage in aggravated criminal sexual abuse between May 2009 and January 2010. Defendant contends that purely intrastate use of cell phone does not constitute use of a facility of interstate commerce. United States versus Lopez. Gonzalez versus Rock. There are limits on Congress' powers to create federal criminal prohibitions on traditionally state-regulated spheres of non-economic activity. But see United States versus Giordano. Finding that the jurisdictional element of 2425 is satisfied by intrastate use of a telephone capable of transmitting communicates between states. Even if purely intrastate use of cell phones constituted use of facility of interstate commerce, the government's evidence that defendant called Juror on the telephone is not sufficient proof that he used the facility of interstate commerce, a cell phone according to the government, to knowingly induce, persuade, entice, or coerce Geronda to come to Olympia Fields to engage in prohibited sexual activity. The government provided no text exchanges showing that the defendant used any words to induce, persuade, entice, or coerce, nor did Geronda testify that during any telephone conversation or on any text messages did defendant use words for the purpose of inducing, persuading, entice, or coercing her to come to his home or studios for prohibited sexual activities. Under the plain reading of the statute, there must be a nexus between the use of the cell phone and the words of persuasion, enticement, or coercion to satisfy a 2422(b) violation. For example, if defendant called Geronda and invited her to a party at his home, and then once there, he coerced her into prohibited sexual activity, that does not constitute a Mann Act violation pursuant 2422(b), since the defendant did not use the facility of interstate commerce, the cell phone, to coerce or induce her into the prohibited sexual activity. Use of the cell phone for some unknown communication, coupled with the subsequent prohibited sex act, is not sufficient to establish a violation of 2422(b). Lastly, if defendant really believed that Geronda was 17 when they engaged in sexual activity, and that belief was reasonable, then he would not be guilty of aggravated criminal sexual abuse. Taking the evidence in the light most favorable to the prosecution, no reasonable juror could conclude that the defendant knew that Geronda was 16 years old when they allegedly engaged in sexual activity between May 2009 and January 2010. Geronda turned 17 years old in April 2010. Government's Exhibit 70, which depicts a photo of Geronda, would fail to put any reasonable person on notice that she was 16 years old rather than 17 years old. The record reflects that Geronda habitually lied about her age. When she was 15 years old, she befriended a 23-year-old woman with whom she would attend defendant's Illinois State Court appearance in 2008. To gain access to those court appearances, Geronda had to demonstrate that she was 18 years of age, presumably by showing an identification. After using her older connections to get invited to a party at defendant's home in Olympia Fields, she sought out the defendant and falsely told him that she was 19 years old. To be clear, there is no evidence that defendant sought out Geronda. Geronda implausibly claims that after going through all the trouble of lying about her age to get close to the defendant and past his security team, she decided to disclose her true age of 16 immediately after their first sexual encounter. Geronda claims that the defendant was indifferent to her age and continued to engage in sexual relations with her until January 2010. The government's evidence falls painfully short of proving that the defendant did not reasonably believe that Geronda was 17 years old at the time of their alleged sexual activities. The government allegedly recovered a copy of Geronda's fake ID and birth certificate in a storage facility purportedly belonging to the defendant. Rather than reach the obvious conclusion that Geronda provided a fake ID to defendant's security team to gain access to the home, the government alleges that the defendant or someone in his inner circle went through the trouble of altering her ID and photocopying it. No rational juror could conclude that defendant engaged in sexual activities with Geronda with the understanding that she was not of legal consenting age. Racketeering Act 6, Forced Labor, Geronda. No rational juror could conclude based on the evidence adduced at trial that defendant knowingly obtained or agreed to obtain any labor or services from Geronda on January 23rd, 2010. A conviction of forced labor under 18 U.S.C. 1589 requires the government to prove beyond a reasonable doubt that, number one, the defendant obtained the labor or services of another person. Two, through inter alia, threats of serious harm. And three, the defendant acted knowingly. United States versus Marcus. The language by means of contained in the forced labor statute, 18 U.S.C. 1589, parent A, requires the government to establish a causal link between the labor and services provided by the person and the threat of serious harm. Serious harm for purposes of 1589, parent A, parent 2 is defined as A, any harm, whether physical or non-physical, including psychological, financial, or reputational harm, that is sufficiently serious under all the surrounding circumstances to compel a reasonable person of the same background and in the same circumstances to perform or to continue to performing labor or service in order to avoid incurring that harm. Section 1589 is intended to address serious trafficking or cases where traffickers threaten harm to third persons, restrain their victims without physical violence or injury, or threaten dire consequences by means other than overt violence. The harm or threat of harm, considered from the vantage point of a reasonable person in the place of the victim, must be sufficiently serious to compel that person to remain in her condition of servitude when she otherwise would have left. Part of a fair reading of a statutory text is recognizing that Congress legislates against that backdrop of certain unexpressed presumption. United States versus Toviav, Section 1589. The forced labor statute was passed to implement the 13th Amendment's prohibition against slavery or involuntary servitude. Congress intended to reach cases in which persons are held in a condition of servitude through nonviolent coercion as well as through physical or legal coercion. According to the government, on an isolated date in January 2010, defendant violated the forced labor statute by using threats of violence to obtain labor in act of oral sex from Geronda. The forced labor statute was not intended to reach isolated conduct like that described by Geronda. Accepting the government's evidence is in its best light, Geronda described an isolated incident in which the defendant allegedly assaulted her because he was angry that she was on her phone and did not properly acknowledge him when he entered the room. Geronda claimed that the defendant slapped and choked her because he didn't believe that I was texting a friend and he got mad about it. Geronda testified that after the purported assault, she sat down with the defendant in the VIP room and he instructed her to perform oral sex on him. Geronda complied with the instruction. Geronda did not testify that the defendant threatened her, forced her, or even demanded that she give him oral sex. Geronda did not claim that she feared the defendant would assault her again if she declined the request. Geronda then left defendant's home and never came back. The government did not establish a causal link between the isolated act of oral sex and any threat of physical violence. Any physical violence that occurred during that episode in January 2010 preceded Geronda providing oral sex to defendant. Geronda's testimony simply does not lead to the reasonable inference that she gave defendant oral sex because she feared physical violence. Geronda did not claim that the defendant used any words suggesting she would suffer an assault if she did not provide him with oral sex, nor did she claim that she feared another assault if she refused his request for oral sex. Geronda did not even testify that she did not want to give defendant oral sex. As troubling as Geronda's story may be, the government still must prove the elements of the crime of forced labor by proof beyond a reasonable doubt. It would not have taken much for Geronda to make the causal link between the act of oral sex and her fear of physical assault by the defendant, but she simply did not provide that testimony. Absent clear expression of congressional intent, courts should resist the urge to transform the forced labor statute to cover the circumstances alleged in Racketeering Act 6, which bear virtually no resemblance to those paradigmatic forced labor cases and their victims. Geronda came in and went as she pleased, even if defendant prohibited her from wandering his property at will. Defendant did not force Geronda into a condition of servitude through threats of physical force and an isolated example of oral sex with an alleged abusive act is just not forced labor. Racketeering Act 7, sexual exploitation of a child, Geronda. The government failed to prove Racketeering Act 7, that is, sexual exploitation of Geronda. According to Geronda, during her 6-month sexual relationship with the defendant, he recorded her with a Canon video camera and on an iPhone. The government produced no images or metadata corroborating this claim. Rather, the government contends that evidence that the defendant owned a Canon video camera and had an iPhone that had the ability to video is sufficient evidence to establish the elements of the offense. The government failed to prove that defendant used, employed, persuaded, induced, or enticed Geronda to take part in sexually explicit conduct for the purpose of producing a visual depiction. To demonstrate that defendant committed sexual exploitation of a child pursuant to 18 U.S.C. 2251(a), it is not enough for Geronda to simply allege that defendant recorded sexually explicit conduct. Geronda's testimony was insufficient to prove that defendant used, persuaded, induced, enticed, or coerced her into sexually explicit conduct. According to Geronda, she had an ongoing sexual relationship with the defendant before defendant allegedly video recorded her, a relationship that the defendant would have no reason to believe was prohibited since Geronda misrepresented her age. Although Geronda described those sexual experiences in hindsight as humiliating, it does not follow that defendant did anything to persuade, induce, entice, or coerce her into the sexual activities that was recorded. The government must prove that the defendant did something more than just film the sexually explicit conduct. If the act of filming or recording alone was sufficient to sustain the charge, Congress would not have included a requirement that the defendant employ, persuade, induce, entice, or coerce. Furthermore, the government failed to prove that defendant acted with the purpose of producing a visual depiction of that conduct. Although the jury was erroneously charged that the government could sustain the charge by proving that the purpose was transmitting a visual depiction, the statute requires something different. Indeed, producing is defined by the statute as producing, directing, manufacturing, issuing, publishing, or advertising. While the statute also prohibits the transmission of live visual depiction, defendant was not charged with transmitting a live visual depiction, and there is no evidence that he did. Lastly, the government's affecting interstate commerce evidence was insufficient where it could not establish what device, if any, was used to make these recordings. Racketeering Act 8, Mann Act violations, Jane. The government failed to prove that defendant committed Mann Act violations in connection with his sexual activity with Jane on or about April 28, 2015 and May 1st, 2015 in the state of California. Jane was 17 years old in May 2015. She concedes that she misrepresented her age to defendant when she met him and kept her true age a secret until fall 2015. After meeting defendant in Orlando, Florida in April 2015, Jane traveled to meet him in California at the end of April 2015. The government charged defendant with 2 Mann Act violations in connection with this trip, alleging first that the defendant violated 18 U.S.C. 2421, paren A. Racketeering, 8A, transportation. Preliminarily, the government's use of the Mann Act under the present set of facts is unprecedented and unjustified. 18 U.S.C. 2421A provides that whoever knowingly transports any individual in interstate or foreign commerce or in any territory or possession of the United States with intent that such individual engage in prostitution or any sexual activity for which any person can be charged with a criminal offense or attempts to do so shall be fined under this title or imprisoned not more than 10 years or both. The government contended that the defendant arranged for Jane to travel to California with the intent of willfully exposing her to a contagious, infectious, or communicable disease in violation of California Health and Safety Code 120290. The government failed to prove a Mann Act violations under 2421, paren A, where it offered insufficient evidence that the defendant, number one, transported Jane with the intent of exposing her to herpes, and 2, committed a violation of California Health and Safety Code 120290 by proof beyond a reasonable doubt. Intent. Because there is no link connecting defendant's transportation of Jane with an intent to expose her to herpes, defendant cannot be guilty of Mann Act violation. The 9th and 10th Circuit Courts of Appeal have held that to establish the intent requirement of the Mann Act violation, the government must prove that the illegal sexual activity is the dominant, significant, or motivating purpose behind the transportation. Let me give some cases. Similarly, in United States versus Hayward, the Third Circuit Court approved the district court's jury instruction that stated, it is not necessary for the government to prove that the illegal sexual activity was the sole purpose for the transportation. A person may have several different purposes or motives for such travel, and each may prompt in varying degrees the act of making the journey. The government must prove beyond a reasonable doubt, however, that a significant or motivating purpose of the travel across state or foreign boundaries was to have the individual transported to engage in the illegal sexual activity. In other words, the illegal sexual activity must have not been merely incident to the trip. In United States versus Campbell, the Fifth Circuit analyzed the intent requirement of 18 U.S.C. 2421 and held that in determining whether a dominant purpose exists, we instead ask whether the illicit behavior is one of the efficient and compelling purposes of the travel. Interpreting the dominant purpose standard to merely significant or compelling or efficient. United States versus Perkins, holding that to prove the intent elements under 2423, paren A, The illicit behavior must be one of the purposes motivating the interstate transportation. The Second Circuit does not seem to have answered the intent question, but whether this court applies a true dominant purpose standard or merely a significant or motivating purpose standard, the result is the same. The defendant alleged violations of a California health law prohibited him from exposing a partner to herpes was incidental to the trip. There is no proof in this record that demonstrate that the defendant's motivating purpose in transporting Jane to California was to expose her to herpes. In fact, the government cannot even show that the motivating purpose of the trip had anything to do with Jane. As Jane herself testified when asked, "And while you were 17, did you take additional trips to California with the defendant?" "Yes, I did." "And do you remember where you traveled to?" "I did not." "Do you remember what the purpose of your travel was for?" "He had shows." In short, no rational juror could find that the government proved that defendant's intent to transport Jane to California was to infect her with herpes. 2. Violation of California Health Safety Code 12290. Second, the government did not prove beyond a reasonable doubt that the defendant committed a violation of the California Health and Safety Code 12290 because the government charged defendant with a repealed version of the statute no longer in effect, a version that reduced the government's burden of proof. Prior to the jury charges in this case, defendant notified the court that the jury instructions did not reflect the elements of California Health and Safety Code 12290. The government acknowledged as much, but argued that it charged defendant under the statute that was in effect in 2015. The government had no authority to charge defendant with the statute that was repealed or inoperative at the time of prosecution. United States versus Chambers. In case a statute is repealed or rendered inoperative, no further proceedings can be had to enforce it in pending prosecution unless competent authority has kept the statute alive for that purpose. In 2015, 12290 of the California Health and Safety Code provided, except in provided in section 12291, or in the case of the removal of an afflicted person in a manner the least dangerous to the public health, any person afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person, and in any person who willfully exposes another person afflicted with the disease to someone else is guilty of a misdemeanor. That the statute was overhauled entirely in 2018 after the California legislature determined that it was antiquated, having been passed during an era of discrimination towards those afflicted with HIV. The current statute bears little to no resemblance to the repealed 2015 version, least of all because it now requires a showing of a specific intent to transmit the disease. Although repealed or inoperative, the government proposed a jury instruction that attempted to reflect the elements of the 2015 statute. Apparently, recognizing that the 2015 statute was unconstitutionally vague in any event, the government stepped into the shoes of the legislature and rewrote the statute to save it from a constitutional challenge. Thus, the government not only charged the defendant with the repeal statute, but rewrote it in clear violation of various constitutional provisions, including the separations of power clause and principles of comity. Defendant's jury was instructed pursuant to a statute that never existed. A California court has no authority to rewrite a California statute, and neither does a district court sitting in New York. Even if the government had the authority to charge the defendant under the 2015 version of 12290 of the California Health and Safety Code, the statute does not pass constitutional muster. Most obviously, the statute is void for vagueness, both on its face and as applied to the defendant. The doctrine of vagueness guards against arbitrary or discriminatory law enforcement by insisting that a statute provides standards to govern the actions of police officers, prosecutors, juries, and judges. As written, the 2015 law fails to provide adequate definitions that put individuals with any chronic and potentially contagious diseases on notice of what amounts to criminal conduct, including communicable diseases that are not sexually transmitted. By way of example, nearly 50% of the population has herpes simplex 1, a communicable disease. Under the 2015 statute, anyone with herpes simplex 1, also known as cold sores, who kisses another person without disclosing that they have herpes simplex 1 is guilty of a misdemeanor. Even if the afflicted person has no active infection, outbreak, and does not pass the disease along to the recipient of the kiss. Under this statute, parents with herpes simplex 1, again, 50% of the population, would be prohibited from kissing their own children. One cannot imagine how many arbitrary prosecutions could take place in this current era of a pandemic if this law was in effect today. Even if the elements of statute were, as the government alleged, insufficient evidence existed to sustain that charge. The government did not prove that the defendant was contagious, infected, or had the capacity to transmit herpes during the sexual encounter he had with Jane in May 2015. Additionally, the government cannot show that the defendant acted willfully with knowledge of the consequences. Presumably, the government assumes that the consequences is transmitting the disease to the person exposed, but effective treatments exist for herpes that significantly reduce outbreaks and the likelihood of transmission. If the defendant was consistently taking Valtrex in April 2015, it cannot be said that he willfully exposed Jane with knowledge of the consequences, particularly since Jane was not infected with herpes in April 2015. This Racketeering Act cannot be sustained where it was based on a repealed law, was rewritten, and facially unconstitutionally in any event. Racketeering Act 8B, Coercion or Enticement. The government alternatively argues that defendant is guilty of the Mann Act, stemming from his April trip to California, because defendant knowingly persuaded, induced, enticed, or coerced Jane to travel to California. Insufficient evidence exists to prove that defendant took any action to induce, persuade, entice, or coerce Jane into traveling to California in April to May 2015. Quite the opposite. The record shows that Jane's mother purposefully and strategically enticed defendant with her 17-year-old daughter, comparing her to Jane Doe number 1 at various points. The government takes great umbrage to this characterization, but the record speaks for itself. Although defense counsel did not make much use of it, Government Exhibit 233 offers powerful evidence showing that the defendant had no reason to induce, persuade, entice, or coerce Jane into going to California with him. Text messages introduced by the government show that Jane, with the guidance of her mother, enticed defendant, who reasonably believed Jane was 18 years old, to bring her to California. In short, when Jane traveled to meet defendant in California in April through May, she required no enticement, persuasion, or encouragement of any kind. On April the 11th, 2015, Jane attended one of the defendant's concerts in Orlando, Florida. After the show, someone provided Jane with defendant's phone number. Jane attempted to text the number on the phone and gave the paper to her mother. Although Jane did not reach defendant, Jane's mother began texting defendant, posing as her 17-year-old daughter. Jane eventually communicated directly with the defendant via FaceTime and told the defendant she was 18 years of age. On April the 20th, 2015, Jane's mother, still posing as Jane, initiated text messages with the defendant and arranged for Jane to meet the defendant at a hotel in Orlando. Government Exhibits 233 shows that Jane and her mother knew from the start that the defendant was interested in Jane sexually, believing that she was of legally consenting age. Before Jane's first meeting with defendants, Jane's mother texted Jane stating, "This man trying to screw, but I'm trying to make it business. He knows you're a singer, but he ain't playing. He wants to F tonight." Despite that Jane and her mother were on notice that defendant was interested in Jane sexually, Jane's mother encouraged Jane to meet defendant. She told Jane to keep defendant's curiosity piqued and advised her about what she should wear to effectively entice him. During her in-court testimony, Jane testified that she went to meet defendant solely to audition for him, but her contemporaneous text messages revealed that Jane was more interested in defendant for personal and romantic reasons. Jane texted her mother, "Oh, he's so fine." When Jane's mother told her to be ready to sing something, Jane said, suggesting that she did not actually want to audition for the defendant. Jane's mother encouraged Jane to tease defendant, but not to do anything sexual with him since he would then lose interest in her. Believing that he was speaking to an 18-year-old, defendant texted Jane's mother that he was staying on the tour bus but was going to get a hotel room for their privacy. Jane's mother then shared that messages with Jane texting, "Yep, he said he's staying on the tour bus, but he wants to get a hotel room for just y'all so y'all can get away from security and managers, etc." Jane's mother gave Jane some final advice before she sent daughter to meet defendant, who believed Jane to be 18 years old. "Be prepared to sing 3 songs. He said he will meet you and listen to your song. Please have your glasses off, hair to side. Mama knows best, pretty hurts. And third, your choice, don't yell. Put on a show. Dance, grab his hand. Shimmy, wiggle, sit on his lap, entice him. While singing, it's all about performance. This is your chance, an opportunity. Don't blow it." Jane's mother even told Jane not to look grown. Emphasis added. "Take off that ugly ass lipstick. I told you he don't want you to be grown. I told you to keep hair curly. That shit looks a mess. You need some jeans or shorts. You trying to look grown. He wanted you because you look young and innocent. That's what he want. Not a little girl trying to be grown. You're a damn fool." Defying her mother's advice to merely tease defendant, Jane engaged in sexual conduct with defendant in the hotel room. Jane stripped down to her undergarments and walked back and forth for defendant. She later acquiesced to removing her clothes, testifying that she got on top of him backwards and he did lick my butt. After the sexual encounter, officer arrived at the hotel room and knocked on the door. After arranging for Jane to meet defendant in his hotel, Jane's parents apparently called the police. Jane described defendant as nervous and anxious, asking her to confirm that she was 18 years old as she had represented. Jane testified at trial after defendant looked through the peephole. He made me go into the restroom and immediately told me to get dressed. And he said, "Are you 18? And I said, "Yes." And he said, "Don't lie to me." And I said, "Yes." Defendant opened the door and the police checked Jane's identification to confirm her age before leaving. Defendant was present when police officers checked Jane's identification. Rather than calling it a night, Jane again removed her clothes and got on top of defendant to continue their sexual activities. After her first encounter with defendant, Jane told her mother that defendant had asked her whether he could fly her to meet him. Jane told her mother, "I said, duh." Jane continued to communicate with the defendant via text messages and by phone, and continued to spend time with the defendant in Orlando doing normal dating activities such as seeing the movies and eating out. At one point, Jane's mother got frustrated with Jane for not prioritizing her music with defendant. On April the 23rd, 2015, Jane's mother texted her, "You need to let him hear your songs. Let him see your video. You're trying to date the man. You need to let him see your shit." Emphasis added. Jane's mother also continued to encourage Jane's relationship with the defendant, telling her to be a little feisty, stating he married Jane Doe number one because she was feisty. She didn't let him run over her. You need to be different than the rest. Later that evening, Jane's mother texted Jane, "You are silly. That man ain't trying to do nothing with you musically. He wants to F period because he like young girls." Jane reassured her mother that the defendant was willing to look at her performances and was patiently waiting to look at some of her videos that her mother had emailed her. On April the 24th, 2015, after the defendant had left Orlando, Jane's mother instructed Jane, "You better be texting him so you will stay on his mind." Later that day, Jane texted her mother about flying out to see defendant at California. Jane, "And I talked to R. Kelly." Mom, "Yeah, about what?" Jane, LMAO, about flying me out. Mom, "Oh, really? When?" Jane, "Yeah, whenever I tell him he can. Tomorrow if I choose." Mom, "Oh, yeah?" On April 28, 2015, Jane traveled to Los Angeles, California to meet defendant with the knowledge and consent of her parents. Jane continued to text with her mother once in LA. At one point, her mother told her, "He going to be in your room butt naked with one of his songs playing." Government's Exhibit 233 reflects that Jane and her mother texted it incessantly while Jane was in LA with defendant. Jane tells her mother at one point, "Crazy, this Jane Doe number one movie just came on and I just got off the phone with R." Mom responded, "Really? Crazy." Jane testified that she had oral sex with defendant in Los Angeles, but she did not share that information with her mother via text. At no point did Jane express any apprehensions about being with the defendant or asked her mother to arrange for her to come home. When Jane excitedly told her mother that she was riding defendant's tour bus to Stockton to attend his concert, Jane's mother responded, "Oh my gosh, exciting. You're riding on the tour bus." On May 1st, 2015, Jane's mother urged Jane to take advantage of defendant, texting her, "It won't be star lifestyle if you don't get serious about your music and show this man you want to be famous like him. Once he's tired of you, you'll be like everybody else. You better use this as your opportunity while you got him in spell." Jane's mother then said, "You should text him and be like, you're going to be my boo, and see what he say." To which Jane responded, "Laughing my ass off." Jane traveled independently to meet defendant in Stockton, California, where he was performing on May 1st, 2015. She stayed in contact with her mother the entire time. At one point, Jane explained to her mother how she ended up going to Stockton to see the defendant's performance. "I told you, he asked me, did I want to come to his show? I said, of course. And he said, okay, then, let's pack this stuff up. He was even putting his stuff in my bag." Jane and her mother remained in constant communication before defendant's show. Jane's mother instructed her about what to wear and made suggestions about how she should behave at defendant's show. I would blow him little kisses and wink at him and bite the tip of my finger, mess with him real good. Do something seductive, then make a silly face. LOL. Jane and her mother continued to text throughout defendant's performance. At one point, Jane and her mother exchanged the following texts. Jane, he's singing this whole show to me. Mom, LOL, too funny. Jane, for real, for real. Jane, LM, laughing my ass off. Jane, this man in love. Mom, oh my gosh, you're going to marry him and have his babies. Mom, LOL, my son-in-law gonna be older than me. Mom, too dang funny. Jane, laughing my ass off. Mom, well, you better get signed first, then married second. Mom, he gonna seduce you tonight. Jane, LOL. Mom, you have to give him a massage before you go to bed. Jane, laughing my ass off. No, I doubt it. Mom, girl, you better or he will get someone else to. Jane's mother continued to encourage her to seduce defendant. At one point, Jane told her mom that she caught feelings for the defendant. According to Jane, she and defendant had sexual intercourse for the first time after the concert. At no point during her travels with defendant in California in April and May 2015 did Jane disclose that she was 17 years of age or that she had lied to him about her age. After the trip to California, Jane traveled to meet defendant in Las Vegas, where he was performing. No rational jury could conclude that defendant enticed, persuaded, induced, or coerced Jane to travel to California. Jane's contemporaneous conversations with her mother show that the defendant invited Jane to join him, and she excitedly accepted. When her mother asked her when he asked her to travel, Jane told her mother, whenever I tell him I can. Tomorrow, if I choose. By her own admission, Jane chose to travel with the defendant because she wanted to, and her mother encouraged her. While this court concluded that Jane's parents' testimony was not relevant for the purpose defense counsel sought to introduce it, Jane's text messages with her mother, introduced as government's Exhibit 233, were highly relevant evidence that defendant took no action to induce, persuade, or coerce Jane to travel with him. Jane was eager to travel with defendant and caught feelings for him, as she admitted, and concealed her age from defendant so she could pursue a relationship with him. The government's evidence fails to show that Jane was persuaded, induced, enticed, or coerced into traveling to California. 7. Racketeering Act 9. Mann Act violations, Jane. The government charged defendant with 4 Mann Act violations stemming from a trip with Jane to California between September 2015 and October 2015, 2 months before her 18th birthday. According to Jane, she disclosed her true age, 17 years of age, prior to this trip. The government's evidence is insufficient as to these Mann Act violations. Racketeering A9A, transportation. For the same reasons argued in connections with Racketeering Act 8A, the government failed to prove beyond a reasonable doubt that the defendant, number 1, transported Jane with the intent of exposing her to herpes in September to October 2015, and number 2, committed a violation of California Health and Safety Code 12290 by proof beyond a reasonable doubt. The arguments set forth supra are equally applicable. Racketeering Act 9A. B. Racketeering Act 9B, coercion or enticement. Insufficient evidence exists to prove that defendant committed Racketeering Act 9B. By all accounts, defendant and Jane were in a serious and legal relationship based in Illinois, where defendant resided in fall 2015. Although Jane testified that she told the defendant her true age after the summer ended in 2015, the record does not reflect precisely when she told defendant her true age. As such, the government failed to show that the defendant possessed the requisite means, ray, to sustain a charge of unlawful sexual intercourse with a person under 18 years old under the California Penal Code in September or October 2015. Furthermore, the record is devoid of evidence that defendant took any action to induce, persuade, entice, or coerce Jane into traveling to California between September and October 2015. Critically, when defendant learned that Jane had lied about her age, he sent her home to Florida. Jane returned to Chicago with her parents' consent. Although it is true that Jane's parents did not have the authority to consent to any illegal sexual activity between Jane and the defendant, their permission to allow her to stay with the defendant is reflective of Jane's desire to continue her relationship with the defendant. Jane offered no testimony to suggest that she was coerced or enticed into traveling to California in fall 2015. Jane's testimony about defendant's rule and sexual proclivities during this time period are not sufficient evidence of coercion to travel, even if Jane now believes with the benefit of hindsight that defendant's conduct was controlling or constituted some type of grooming. C. Racketeering Act 9C, coercion or enticement. The government charged defendant with the Mann Act violation under the separate theory that defendant transported Jane to California in September or October 2015 with the intent to violate California Penal Law sections 261.5(a) and 261.5(b), unlawful sexual intercourse with a person under 18. Preliminarily, for the reason argued supra, the government simply failed to prove that defendant took any action to induce, persuade, entice, or coerce Jane into traveling to California. By late 2015, defendant and Jane were in a serious relationship based primarily in Illinois, where defendant resided. The age of consent in Illinois is 17. Therefore, the defendant and Jane's sexual relationship was not prohibited there. Jane traveled with defendant to numerous states as one of his partners. She went consensually and voluntarily. Defendant did not have to induce, persuade, entice, or coerce her to travel. Even if the government is correct that defendant had exerted some dominance or control in the relationship at the time. Furthermore, as argued in connection with Racketeering Act 5, the government provided insufficient evidence that defendant used any words to induce, persuade, entice, or coerce Jane to travel to California via a facility of interstate commerce. Under the plain reading of the statute, there must be a nexus between the use of the facility of interstate commerce, a cell phone, computer, and the words of persuasion, enticement, or coercion to satisfy a 2422(b) violation. The record is devoid of that proof. The mere fact that defendant texted it with Jane about any number of things does not satisfy the interstate commerce element of this Mann Act violation. D. Racketeering Act 9D, transportation. Is it true that in the state of California, the age of consent is 18? According to Jane, she had sexual relations with the defendant in California during this trip when she was still 17 years of age. However, the government failed to prove defendant guilty of the Mann Act under this theory, where defendant's motivating purpose in traveling to California was not to have sex with Jane. Defendant and Jane had a consensual and legal sexual relationship in Illinois. Defendant's purpose in traveling to California was to perform, and he arranged for his girlfriend to go with him. If defendant had sexual relations with Jane in California in September and October, it was purely incidental to the purpose of the trip, as Jane herself testified when asked. Question: and while you were 17, did you take additional trips to California with the defendant? Answer: yes, I did. Question, and do you remember where you traveled to? Answer, I do not. Question, do you remember what the purpose of your travel was for? A, he had shows. No rational juror could find that the government provided that defendant's motivating purpose in transporting Jane to California was to have sexual intercourse with her, particularly where he had an ongoing legal and consensual sexual relationship with her in the state of Illinois where he resided. At bottom, no nexus exists between the transportation of Jane and the alleged illegal sexual activity. 8. Racketeering Act 10, sexual exploitation of Jane. The government failed to prove Racketeering Act 10, that is, sexual exploitation of Jane, where it offered insufficient evidence that defendant used, employed, persuaded, induced, or enticed Jane to take part in sexually explicit conduct for the purpose of producing a visual depiction between September 2015 and December 30th. The government contends that prior to Jane's 18th birthday, defendant recorded his sexual experiences with her in California. To demonstrate that defendant committed sexual exploitation of a child pursuant to 18 U.S.C. 2251(a), it is not enough for Jane to simply allege that defendant recorded sexually explicit conduct. Jane offered no testimony that proved that the defendant used, persuaded, induced, enticed, or coerced her into sexually explicit conduct during the relevant time period. Jane had an ongoing sexual relationship with the defendant before the video recording incident and after the video recorded incident. Although Jane seems to regret those experiences, she did not offer sufficient evidence of enticement or coercion. The government must prove that the defendant did something more than just film the sexually explicit conduct. If the act of filming or recording alone was sufficient to sustain the charge, Congress would not have included a requirement that the defendant employ, persuade, induce, entice, or coerce. Furthermore, the government failed to prove that defendant acted with the purpose of producing a visual depiction of that conduct. Although the jury was erroneously charged that the government could sustain the charge by proving that the purpose was transmitting a visual depiction. The statute requires something different. Indeed, producing is defined by the statute as producing, directing, manufacturing, issuing, publishing, or advertising. 18 U.S.C. 2256(3). While the statute also prohibits the transmission of live visual depictions, defendant was not charged with transmitting a live visual depiction, and there is no evidence that he did. Accordingly, the government failed to prove Racketeering Act 10 by proof beyond a reasonable doubt. 9. Racketeering Act 11, forced labor of Jane. The government charged defendant with forced labor of Jane under the theory that defendant required Jane to participate in sex with other men and other women. Although at trial, Jane claimed that she did not want to participate in those activities and that she did not enjoy those activities, that does not mean that Jane was forced to participate in those activities. If Jane refuses even now to allege that she was forced by threats of violence to engage in certain sex acts, it is unclear why the government believes she was. Again, belatedly acknowledging that one really did not want to participate in the conduct is not the equivalent of being forced. The record is devoid of any evidence that Jane was forced within the meaning of the statute to have sex with individuals other than the defendant, or that she was prohibited in any way from extricating herself from the relationship. It's 10 more pages left. Perspective, you want to pick back up?
Sure.
Okay.
Hold on, let me lock my door. Hold on one
Okay, let me go on mute.
Okay. The government's evidence that Jane was forced to participate in these sexual acts consisted of Alex's nephew's testimony that some women he had sex with were zombie-ish, and that defendant had directed women other than Jane to participate in group sex. Rather than point the jury to specific evidence from Jane's testimony that reflected that she had been forced to participate in these activities through violence, restraint, or threat of violence, the government argued that the defendant had directed Dominique to have sexual intercourse with Alex. While the government was permitted to offer an extraordinary amount of uncharged bad act evidence for various purposes, such evidence cannot supplant the government's burden to show that Jane herself was forced to participate in group sex acts. The evidence offered was insufficient proof of the offense of forced labor. As discussed in connection with Racketeering Act 6, the government cannot establish the offense of forced labor by simply showing that the defendant and Jane had a sexual relationship that some might consider abusive. The government was required to establish a causal link between the group sex acts and threats of physical violence. It failed to do so. Racketeering Act 12, Mann Act violations, faith. The government charged defendant with 2 Mann Act violations in connection with Faith's trip to New York in May 2017, alleging that defendant violated 18 U.S.C. 242A and 2422A. The government charged that defendant either transported or persuaded, induced, enticed, or coerced Faith to travel to New York with the purpose of knowingly exposing her to an infectious venereal disease under New York Public Health Law Section 2307 and reckless endangerment pursuant to New York Penal Law Section 120.20. The government failed to prove Mann Act violation under 2421A and 2422A, where it offered insufficient evidence that defendant 1 transported Faith with the intent of exposing her to herpes, or 2 persuaded, induced, enticed, or coerced Faith to travel to New York with the intent of exposing her to herpes. Separately, the government failed to prove that defendant committed the offense of reckless endangerment or a violation, New York Public Health Law, Section 2307, which is unconstitutional in any event, both facially and as applied to the defendant intent. Because there is no link connecting defendant's transportation of Faith with an intent to expose her to herpes, defendant cannot be guilty of Mann Act violation. As discussed at length, the government must prove that the illegal sexual activity is the dominant significant or motivating purpose, behind the transportation. Then they list cases. Because the defendant's purported violation of the New York Public Health Law prohibiting him from exposing a partner to herpes was incidental to Faith's trip rather than a motivating purpose in transporting Faith, the intent requirement of the statute cannot be sustained. The government argued to the jury that it should find defendant guilty of a Mann Act violation by merely finding that the defendant transported Faith to New York from her hometown in Texas for the purposes of sex. The only remaining issue is whether the sexual activity that he brought her here for was illegal, and it was R4433. This argument is legally flawed. The transportating Faith to New York to have sex would not satisfy the elements of a violation under Section 2421A, since the sex act itself was perfectly legal as Faith was a consenting adult. The activity that was allegedly illegal in New York was exposing Faith to herpes. It is that act that must be motivating purpose behind defendant's transportation of Faith, because the government cannot demonstrate a nexus between defendant's motivation for transporting Faith to New York and the illegal sexual activity, defendant must be acquitted of the 2421 offense. Coercion and enticement. The government alternatively argued that defendant is guilty of the Mann Act stemming from Faith's trip, May 18th to 2017 trip to New York because defendant knowingly persuaded, induced, enticed, and coerced Jane to travel to New York for the purpose of exposing her to herpes. Insufficient evidence exists to prove that the defendant took any action to induce, persuade, entice, or coerce Jane into traveling to New York on May 18th, 2017. The evidence shows that defendant invited a grown woman to meet him in New York and she accepted. March 2017, Faith attended one of the defendant's concerts in San Antonio, Texas, with her sister. Faith had an opportunity to meet defendant at an after party backstage along with other individuals. Defendant and Faith had a conversation during the after party and defendant provided her with his phone number. After that encounter, Faith and defendant kept in touch via text and FaceTime. The conversations were normal, appropriate, and pleasant. Defendant complimented her appearance. Faith testified that the defendant referred to himself as daddy during those conversations. According to Faith, defendant asked to be called by daddy, and she complied. Faith did not testify that the defendant forced her to call him daddy. Indeed, defendant and Faith had met exactly one time when Faith began calling him daddy. On the issue of travel, Faith had this to say. Question. In your communication with the defendant, how, if at all, did the topic of traveling to see him come up? Answer. He had informed me that he was on tour right now, or at the time, he was on tour. So he was just saying his schedule was kind of crazy. But whenever I wanted to come see him, I could. And he just said that he could arrange the days or just let him know when I wanted to come hang out. But that it would be fun. I would get to see, how it is, how he is on tour, things like that. Defendant told Faith that if she wanted to come to his shows, she could contact his assistant and he would arrange it for her. Faith then contacted the defendant's assistant who made travel arrangements for her. Originally, Faith was going to travel to Chicago, but ultimately traveled to New York for one of the defendant's performances. According to Faith, defendant informed her that he was having a show in New York and that he would like for me to come hang out. It was going to be fun, so I said yes. Defendant's assistants arranged her travel and Faith traveled to New York and attended defendant's performance and hang out. No rational juror could conclude from Faith's testimony that the defendant coerced or enticed her to travel to New York for the purpose of giving her herpes. By Faith's account, defendant was polite, generous, and appropriate, leaving it entirely at her discretion to come to New York to attend a concert. Defendant's alleged bad behavior with other women is not sufficient evidence of his specific conduct in connection with Faith on May 18th, 2017. The government routinely asked the juror to find that it had proven elements of the charged offense simply because defendant had, from the government's perspective, been controlling and coercive to other women. Faith's testimony does not establish any conduct on the part of defendant that shows that he did anything other than invite her to come to his concert in New York, an invitation she accepted. Frankly, if the conduct proves coercion and enticement by proof beyond a reasonable doubt, the government is going to be very busy prosecuting Mann Act violations. Although it seems unlikely that the government has much of an intention of using this provision to prosecute influential, wealthy white men who invite women on fancy trips for the purpose of engaging in sexual activity that those women later decide was unpleasant. New York Public Health Law Section 2307 and Penal Law 120.20. To sustain the Mann Act violation charge in connection with Faith's travel to visit defendant in New York on February 2nd, 2018. The government must prove that the defendant intended to engage in sexual activity for which he could be charged with a criminal offense. Pushing the boundaries of its prosecutorial discretion, the government alleged that the defendant could have been charged with a violation of New York Public Health Law 2307 and/or reckless endangerment because he created a substantial risk of serious physical injury when he had unprotected sex with Faith, knowing that he had herpes. At the outset, Faith did not contract genital herpes from defendant despite her misleading testimony. After returning from New York, Faith claimed she was diagnosed with herpes type 1 after getting cold sores on her mouth. Nearly 50% of the population has herpes type 1, and it can be contracted in any number of ways, including kissing, sharing a toothbrush, or eating utensils. Cold sores caused by herpes type 1 does not cause a substantial risk of serious physical injury. Presumably, even the government would concede this point. Furthermore, as a matter of law, unprotected sex with someone who has genital herpes does not establish a substantial risk of serious physical injury. According to the City Health Department, 1 in 4 New Yorkers has genital herpes. If sexual intercourse with individuals who merely carry the genital herpes virus carries a substantial risk of serious physical injury, New York City would have an astronomical hospitalization and death rate from the transmission of herpes. Although the government's expert witness identified some serious but unusual health risks associated with the contraction of genital herpes, the offense of reckless endangerment requires a showing of a substantial risk of serious physical injury. Serious physical injury is defined as a person's physical condition that creates a substantial risk of death or serious and protracted impairment of health. The government did not satisfy this burden. The risk of defendant transmitting genital herpes to Faith is unknown, where he did not transmit it to her, and there is no evidence that he was contagious or had an outbreak. If the government could show that the defendant had active symptoms of herpes when he had intercourse with Faith, their proofs might be on a better footing. But merely having unprotected sex with someone who carries the virus can not, as a matter of law, create a substantial risk of serious physical injury. Notably, the government cannot point to a single case that supports the prosecution's expansive reading of this statute. Even if defendant had given Faith genital herpes, the government's evidence would be insufficient to sustain a charge for reckless endangerment. Herpes is not deadly and rarely causes any serious protracted health impairments. Again, the government expert witness identified rare complications from herpes that could perhaps meet the definition under the reckless endangerment statute. But since those complications carry a low rather than substantial risk of serious physical injury as defined by the statute, the government cannot, as a matter of law, sustain this claim. Separately, New York Public Health Law 2307 is unconstitutional. Facially, as applied, for the reasons previously identified by the defendant in his motion to strike allegations from count 1 of the superseding indictment and dismiss the remaining counts. Additionally, the statute is void for vagueness, as it fails to put the public on notice of what conduct constitutes criminal behavior and authorizes arbitrary and discriminatory enforcement. Sessions versus DeMaya, 138. 1 in 6 Americans, 1 in 4 New Yorkers suffer from genital herpes, herpes simplex 2. Under the plain reading of this statute, even a person who carries the virus but has been asymptomatic for decades would commit a crime by having sexual intercourse with another. In the absence of a definition of infected, the statute is unconstitutionally vague. While this court seems to assume that infected means having the virus rather than having the ability to transmit it, no authority supports this application, and such an interpretation would lead to arbitrary and discriminatory enforcement. Racketeering Act 13, forced labor, faith. No rational juror can conclude based on the evidence adduced at trial that defendant knowingly obtained or agreed to obtain any labor or services from faith on 2018. Under 18 U.S.C. government to prove beyond a reasonable doubt that 1, the defendant obtained the labor or services of another person. 2, through inter alia, threats of serious harm. And 3, the defendant acted knowingly. United States versus Marcus 487, Supreme Court 387, 310, EDNY 2007. The language by means of contained in the forced labor statute 18 USC 1589A requires that the government to establish a consensual link between the labor and the services provided by the person and the threat of serious harm. ID section 1589 is intended to address serious trafficking or cases where traffickers threaten harm to third persons, restrain their victims without physical violence or injury, or threaten dire consequences by means other than overt violence. The harm or threat of harm considered from the vantage point of a reasonable person in the place of the victim must be sufficiently serious to compel that person to remain in her condition or servitude when she otherwise would have left. According to the government, on January 13, 2018, defendant violated the forced labor statute by using threats of violence to obtain labor, an act of oral sex from faith. The forced labor statute was not intended to reach isolated conduct like that described by Faith. Faith testified that she traveled to Los Angeles to see defendant, presumably to continue her romantic sexual relationship with the defendant. She described an incident where she and defendant were in a small room in Los Angeles studio where he worked. According to Faith, there was a gun in the room that made Faith intimidated, but the defendant never touched the gun, threatened her with it, or made any gestures that he intended to use it. Faith was simply uncomfortable by its presence. After an intense conversation during which Faith described defendant as being serious but not threatening, defendant directed her to give him an oral sex and grab her neck before placing his penis inside of her mouth. Without objection, Faith provided oral sex to the defendant, although she testified that she did not want to. The forced labor statute was not enacted to remedy isolated occurrences like the one described by Faith. Indeed, it is not even clear from Faith's testimony that she gave any indication to the defendant that she did not want to give him oral sex. Although she claimed she did not want to give him oral sex, the record fails to reflect a casual link between the isolated act of oral sex and any threat of physical violence. Even if Faith felt intimidated by being in the same room where a gun was located, this event did not amount to forced labor. Furthermore, Faith traveled to visit the defendant against even after the alleged act of forced labor, where she now claims she did not want to participate in the act of oral sex. Okay, Racketeering Act 14, Faith. The government charged defendant with a second set of Mann Act violations in relation to Faith's second trip to New York on February 2nd, 2018. The government's evidence was insufficient for the same reason argued in connection with Racketeering Act 11. First, the government simply fails to demonstrate that the defendant transported Faith to New York on February 2nd, 2018 for the purpose of exposing her to herpes. Second, the record is devoid of any testimony that the defendant coerced or entice Faith to come to New York for the purpose of exposing her to herpes. Faith and defendant's so-called relationship was conducted almost entirely over text. After meeting at defendant's concert in San Antonio, Faith met the defendant face-to-face no more than 5 times. Faith always returned to her home in Texas after her short excursions to visit the defendant. This was a grown woman who made decisions to travel with defendant not out of fear, coercion, or any type of enticement, but because she wanted to. Faith herself refuses to identify as someone who was forced to do anything. On cross-examination, Faith admitted that she was not a victim and had made a choice to be with the defendant. Question. In one of the podcasts we spoke about this morning, the paper route, on that show, you said during the interview, I don't like the word victim because I don't feel like I'm a victim. I'm a young woman, and let's be clear. I made a choice to be involved with that person. Do I feel everything he did was right? Hell no. But I had a choice, and that's why I walked away. I did not move in with him. I did not live with him. I did not take any money from him. There is a choice that you have to make. You said that. Correct. You made a choice. Correct. And you're not a victim. Correct. The record is devoid of evidence that proves that the defendant coerced or enticed Faith to travel to New York in February 2018. The government must point to some specific words or conduct by the defendant that would that were coercive or enticing in respect to Faith. An invitation is simply not enough. Accordingly, the government failed to prove Racketeering Act 14. In sum, the government failed to prove the defendant guilty of RICO. The government failed to prove counts 2 through 9 of the indictment. The government charged defendant with 4 freestanding Mann Act charges that mirror Racketeering Acts 8 and 9 related to Jane. For the reasons argued, supra pages 29 through 42. The government failed to prove counts 2 through 5 of the indictment. Similarly, the government charged defendant with 4 freestanding Mann Act violations that mirror Racketeering Acts 12 and 14. For the reasons argued, supra 47 through 53 and 55 through 56, the government failed to prove counts 6 through 9 of the indictment. For the foregoing reasons, this court should enter an order acquitting defendant of all offenses. Respectfully submitted, Jennifer Bonjean.
Woo! Go on, Jennifer. Now I'm gotta go to the next one. Woo! That was bad. That was good. What y'all think? What y'all think?
Yeah, she did. Oh.
She was hitting them. She was hitting them.
She hit it. Now the next one was good. The next one's good also.
Does anybody else hear an echo?
Yeah, I hear y'all echo because they're both open at the same time.
Oh, okay. Well, let me mute.
You still hear it?
Nope.
Okay.
All right, here's the memorandum to support new trial. This one's not
okay.
long.
Let me go and open that.
You got it.
Wow, I don't know. Whew, that's a lot.
This one?
No, the what we just read. I'm just like I'm kind of excited, so I'm like it's like a head rush.
Oh, this one here is good. This one here is about the jurors.
Motion 1?
The one that's coming up now. It's a jurors, Nicole. It's a lot of it.
Defense. Okay, I want to make sure I'm opening the right one. Am I opening defendant Robert Kelly's notice of motion for judgment? No, that's not that.
No, the one 270.
270.
When you open it, it's going to say 270-1.
The one for a new trial?
Yes.
Got it.
Okay, okay.
Okay.
This one has
22 pages.
and the jurors in it.
Okay. 22 pages, you guys.
It's not that bad, y'all. But it's good. It's really short, this one.
I'm just scrolling down to get to the beginning.
Rhoda, you want to start that one?
Okay. You want me to start at the introduction?
Yeah.
Okay. It is axiomatic that a defendant is entitled to the effective assistance of counsel. U.S. Constitution Amendment number 6, incorporated in Defendant's Sixth Amendment, guaranteed is the right to conflict-free counsel. Defendant was denied his Sixth Amendment guarantees in a number of ways, some of which are clear from the record, some of which are not. In this complex RICO prosecutions, defendant's legal team fell apart mere weeks before the commencement of trial. The docket reflects that defendant's lawyers were unable to effectively represent defendant as a team. Energy, resources, and time that should have been devoted to preparing for trial were expended battling each other until two of defendant's more experienced attorneys were granted leave to withdraw. Defendant was left with a disjointed, unprepared trial team and no singular defense strategy. This motion identifies two serious violations of defendant's Sixth Amendment constitutional guarantees that require a new trial and are apparent from the record. Specifically, defendant is entitled to a new trial where his trial team conducted no meaningful voir dire in equities to the seating of jurors who were unqualified to serve on this jury. Defendant was also denied conflict-free counsel, where his attorney, Ms. Becker, simultaneously represented one of the government's key witnesses. These violations of defendant's Sixth Amendment rights are so serious as to demand a new trial without showing of prejudice. Federal Rule, legal standard, Federal Rule of Criminal Procedure 33 provides that upon the defendant's motion, the court may vacate any judgment and grant a new trial if the interest of justice so requires. Unlike Rule 29, Rule 33 confers broad discretion upon a trial court to set aside a jury verdict and order a new trial to avert a perceived miscarriage of justice. But such discretion should be exercised sparingly. United States versus Sanchez. Argument number 1. Defendant was denied effective assistance of counsel where his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of whom had watched the inflammatory docuseries Surviving R. Kelly or were familiar with prior accusations of sexual abuse of minors against defendant. Counsel's objectively unreasonable performance during voir dire resulted in the impaneling of a jury that was neither fair nor impartial. As United States Supreme Court Justice Black stated in Re. Michael 326 U.S. 224-228, 1945, it is difficult to conceive of a more effective obstruction to the judicial process than a juror who has prejudged the case. That is because due process means a jury capable and willing to decide the case solely on the evidence before it in a trial court, ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. Smith versus Phillips. In Irwin versus Dowd, the United States Supreme Court observed the right to a jury trial guarantees to the criminal accused a fair trial by a panel of impartial and indifferent jurors. This is true regardless of the heinousness of the crime charged, the apparent guilty of the offender, or the station in life which he occupied. A juror who has formed an opinion cannot be impartial. Internal citations omitted. Rule 24 of the Federal Rules of Criminal Procedure governs voir dire in criminal trials. The rule provides that if the court examines jurors, it must permit the attorney for the parties to A, ask further questions that the court considers proper, or B, submit further questions that the court may ask if it considers them proper. Federal R. P. page 24, paren A, a trial judge who under Rule 24 decides to examine prospective jurors himself must at the very least solicit questions from both parties' attorney, United States versus Laird. Naturally, the trial court's duty to ensure that each and every juror is fair and impartial is heightened where, as here, pretrial publicity has greatly increased the odds that a potential juror has preconceived views of the accused's guilt. Water versus Shutter. In a case of substantial pretrial publicity, jurors' subjective assessment of their own impartiality may not adequately screen for the possibility of prejudice. In an effort to protect defendants' cherished guarantee of a fair and impartial jury trial, this court implemented a procedure whereby potential jurors were asked to complete questionnaires that probe whether they had prior knowledge, preconceived notions, or biases about defendant given the unprecedented pretrial publicity he faced. Indeed, the questionnaire contained an entire section entitled Knowledge of the Case and People that asked jurors to reveal whether they had read, seen, or heard anything about the case, the alleged crimes or people involved, and to describe in detail any information they had previously learned by the defendant. The questionnaire expressly asked prospective jurors whether they had watched or heard any interviews of Robert Kelly, of any TV shows featuring him, or any specials or documentaries about him. The court invited counsel for the government and the defendant to review the questionnaires in advance of jury selection and to determine whether they could agree that certain individuals should be excluded for cause. The parties conducted that process and identified a set of potential jurors for the voir dire process. Inexplicably, defendant's counsel failed to challenge several jurors who ultimately sat on defendant's jury who were clearly unqualified to serve on an account of their preconceived beliefs about defendant's guilt. These decisions cannot be justified by trial strategy, where the record fails to reflect that trial counsel conducted a sufficient inquiry to probe these jurors' biases. Indeed, trial counsel was mostly silent throughout the voir dire. Although the court was responsible for questioning prospective jurors, it afforded the parties the opportunity to weigh in the questioning of prospective jurors who had made representations in their questionnaires that raised red flags. These questionnaires were highly effective tools for putting the parties on notices of jurors who might not be qualified to serve. But trial counsel made no effort to drill down on troubling representation that demanded further inquiry to ensure that the juror could be fair and impartial, regardless of any juror assurances he or she provided to follow the court's instruction. Perhaps most troubling, most of the defendant's jurors were aware of prior allegations of sexual abuse against him, and several seated jurors had actually seen a scathing, one-sided docuseries entitled Surviving R. Kelly that portrayed the defendant as a serial predator, included interviews with many of the government's witnesses, albeit outside the adversarial process. Defendant's jury should not have included a single person who saw the documentary, Surviving R. Kelly. It defies all logic that a jury could possibly remain indifferent and consider only the evidence heard from the witness stand after watching the docuseries. But this court could not make cause challenges for defendant or do defense counsel's job for it. although it tried at points. It was defense counsel's responsibility to conduct a meaningful voir dire, particularly in this highly publicized case, to ensure that defendant's jury was fair and impartial. Trial counsel failed in its duty. For example, juror number 3 provided the following information in the questionnaire. Question 29. The case for which you are summoned involved the defendant, Robert Sylvester Kelly, also known as R. Kelly. Have you read, seen, or heard anything about the case? Alleged crimes or people involved? I watched the documentary, but I forgot the name of it. Question 30. Have you read, seen, or heard about Robert Kelly, also known as R. Kelly? Yes, entertainer. I heard that he has been sleeping with underage girls. Question 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Answer, yes. Question, what were your general impressions? Answer, I saw a documentary about him and his legal troubles. I don't know the full story, so I have no feelings and remain impartial. Question 91, do you know anything about the Me Too movement? Answer, yes. It's a movement that seeks justice for rape victims 25 to 30 years after the fact. Trial counsel did not ask the court to question the juror further about his responses to these questions or to determine whether the juror could truly serve as impartial and unbiased juror in light, having seen the salacious and highly prejudicial docuseries. Not a single question was asked of the juror about his impressions of the documentary, nor did counsel ask the court to inquire about what information he learned about defendant's prior legal issues or his reputation for sleeping with underage girls. Frankly, anyone who had seen the docuseries should have been automatically removed for cause. Juror number 4 revealed in the questionnaire. Question number 39. The charge in this case involves allegations regarding exposure to one or more sexually transmitted diseases. Is there anything about such an allegation that you believe would affect your ability to serve as a fair and impartial juror? Answer, yes. I find transmission of STDs in a non-consensual act to be particularly repulsive. Question number 55. Have you ever known anyone, including yourself, who was the victim of a sexual assault, other assault or homicide, or other act of violence that required medical treatment or counseling? Answer, yes. Close friend received asylum due to sexual assault and infection with HIV from the police in a foreign country. Question 78. Which publicly known person do you least admire? Answer, Jeffrey Epstein. Although the court generally asked whether anything the juror read would affect his or her ability to be fair and impartial in the case, and the juror replied, not that I know of, but trial counsel did not ask the court to question the juror whether his feelings of repulsions about the transmission of STDs in a non-consensual scenario would interfere with his ability to serve as fair and impartial juror. No conceivable reason exists for failing to inquire further about the juror's feeling about the transmission of STDs in a non-consensual circumstance where the government charged defendant with precisely that act. Incredibly, this juror willingly disclosed that the publicly known person he least admired is Jeffrey Epstein, an accused pedophile. Just like the defendant, with no meaning inquiry about whether this juror could truly serve as a fair and impartial juror, the juror was seated. Juror number 5 disclosed the following in his or her questionnaire. Question 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Answer, yes. Question, what were your general impressions? Answer, he loves underage girls. Question 32. From what you have seen or heard, do you have a general impression of the defendant? Answer, somewhat negative. Question, why do you feel that way? Answer, the allegation that related he was sleeping with underage girls, parentheses minors. Although the court asked the prospective juror general questions about her ability to put aside other things she might have heard, when asked if he or she could be fair, the juror indicated that he or she would give it a shot. The court reminded the juror that he or she had to be certain that she would consider only evidence offered at trial, and the juror acquiesced. Incredibly, the court seemed very concerned about this juror's ability to be fair, observing, "So I don't know about you, but when someone says they think they can do something in this context, I don't think that's an unqualified assurance. And I don't know what the party's position is on that. I think I pushed her pretty hard on it, and we still ended up with, I think so. Let me hear from the government if you have a position on that." Not surprisingly, the government was confident that the juror indicated she could be fair. The court still expressed doubt. Inexplicably, trial counsel agreed with the government and the juror was seated. To be blunt, defense counsel agreed to the seating of a juror who not only was surviving R. Kelly, but concluded that defendant loves underage girls. There simply cannot be any route strategy for failing to excuse this juror for cause. Had trial counsel challenged this clearly unqualified juror, the court seemingly would have struck him or her for cause. Trial counsel not only didn't move to disqualify the juror, he did not even ask the court to probe more deeply into the juror's statements on the questionnaire that defendants love underage girls. Juror number 7 also revealed in his questionnaire that he had heard about the case and the alleged crimes. Trial counsel did not ask the court to question the juror further about what he heard specifically or where he heard it. The court merely asked the juror whether he could put aside what he heard and rely on the evidence presented in the case. Juror number 8 also disclosed that he or she had heard about crimes the defendant is alleged to have committed, and further indicated that he or she believed that the allegations related to another case in another state. Again, trial counsel failed to probe what precisely the prospective juror had heard or conduct a meaningful inquiry into whether she could be fair given what she had heard. Juror number 9 also indicated that she knew that the defendant had issues with the law, but could not say exact what for. She also described the Me Too movement as the power structure of the male-dominated move industry has been turned on its head. Again, trial counsel did not ask the court to question this juror about any details she may have heard about defendant's issues with the law, nor did he ask that the court inquire about the defendant's views concerning the Me Too movement and role in changing power dynamics in the male-dominated movie industry. Juror number 11 similarly disclosed that he or she saw this case mentioned on the news when he was first being investigated, and that she had read or seen that he had allegations of misconduct logged against him. Shockingly, trial counsel did not ask the court to follow up on any of these important revelations to determine whether this juror was qualified. Juror number 12 offered several concerning answers in response to the questionnaire. Question 29. Have you read, seen, or heard anything about the case? The alleged crimes or people involved? Answer, yes. Question. Describe in detail what you recall reading, seeing, or hearing about, etc. Answer. Sex with minors. Specific details do not come to mind. Parodies on TV regarding details of defendant's personal life. Saturday Night Live, Dave Chappelle. Was he in jail prior to being released? Question 30. Have you read, seen, or heard about R. Kelly? Answer, yes. Same as answer above. Various instances of achievement in musical career, songs on the radio, videos, entertainment news shows. Specifics are not remembered. Question 32. From what you have seen, read, or heard, do you have a general impression of the defendant? Answer, somewhat negative. Question, why? Answer, I really never cared one way or the other regarding the defendant. The somewhat negative impression is an emotional one impacted by the nature of the charges against him. Question 91. Do you know anything about the Me Too movement? Answer. Entertainment industry-led movement encouraging women to come forward and name their accusers. Associate it with accusers of Harvey Weinstein, various news articles and TV news segments. Trial counsel questioned the juror about his or her ability to be fair and obtain assurances from the juror that he or she could. but trial counsel did not bother to ask the court to inquire about the juror's reference to defendant's personal life, sex with minors, or Dave Chappelle's Saturday Night Live skit, which referenced prior allegations against defendant of videotaping a sexual encounter that depicted him urinating on a minor, a crime for which he was prosecuted, although not convicted. It is beyond comprehension that trial counsel would not have sought to inquire further of this juror about his prior knowledge about allegations against defendant, or press whether he could truly be fair given the information with which he came to the jury. Nearly all of the alternative jurors admitted that they were aware of allegations of sexual abuse against defendant. In fact, one of the alternative jurors stated, "No, there have been accusations related to this for quite some time. Think defendant was married to Jane Doe number 1, who was underage at the time," and further admitted that she had seen defendant's interview with Gayle King in which he stood up and yelled to defend himself. Although defense counsel indicated that he intended to challenge this alternate for cause, no motion was formally made and the alternate remained on the jury. Critically, alternate juror number 4 revealed that she was aware that the defendant was married to Jane Doe number 1 when she was young, but claimed that she had not really heard much about the case and assured the court she could be fair. Again, trial counsel had no follow-up questions for this alternate juror. Notably, this juror apparently was familiar with well-known Me Too lawyer Gloria Allred, who represented some of the government's witnesses, and asked if she could get Allred's autograph in the middle of the trial. Defendant had no chance to defend himself, where most of the jurors in his case were fully aware of his prior legal issues. Some had watched the Damning and docuseries Surviving R. Kelly, and many seemed to accept that he was known for abusing minors. Frankly, everyone in the courtroom seemed to accept that defendant's jury would be prejudiced against him and made virtually no effort to impanel a truly unbiased jury. Although the court generally asked jurors about their ability to be fair, it was counsel's job to elicit as much information as possible to determine whether the juror could actually be fair. As stated previously, in a case of substantial pretrial publicity, jurors' subjective assessment of their own impartiality may not adequately screen for the possibility of prejudice. Wardoff, 3F 3D at 710. Voir plays a critical function in assuring the criminal defendant that his Sixth Amendment right to an impartial jury be honored. Rosales-Lopez versus United States. As early as 1895, the Supreme Court in Connors versus United States explained that an adequate voir dire is essential to ensure that prospective jurors will be free of bias or prejudice and will perform their duties impartially. The primary purpose of the voir dire is to make possible the impaneling of an impartial jury through questions that permit the intelligent exercise of challenge by counsel. United States versus Blunt. Defendant received ineffective assistance of counsel where his trial counsel failed to conduct any meaningful voir dire of prospective jurors to ensure they were free of bias or prejudice. Counsel also failed to challenge jurors who were clearly disqualified from serving, including those who had seen the highly prejudicial documentary Surviving R. Kelly. To prevail on the claim of ineffective assistance of counsel, a defendant must demonstrate both that his attorney's representation was unreasonable under the prevailing professional norms and that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceedings would have been different. Strickland versus Washington. Trial counsel's performance was unreasonable under prevailing professional norms, where he failed to question clearly biased jurors about the extent of their knowledge about defendants' prior legal issues, allegations of sexual abuse, and their feelings about the documentary Surviving R. Kelly. An attorney cannot make an intelligent decision about whether to challenge a potential juror for cause or whether to exercise the defendant's preemptory challenges without properly questioning potential jurors to learn of potential biases. In this case, numerous jurors divulged that they had prior biases from having learned information about the defendants through other sources prior to the jury selection process. Their own subjective subjective assurances that they could be fair was not sufficient to ensure that they did not harbor beliefs or preconceived ideas about defendant's guilt. Significantly, one alter juror saw Me Too lawyer Gloria Allred in the courtroom. Allred represented a few of the government's witnesses and was a common fixture on all media platforms, declaring defendant the worst predator she had ever pursued. During the middle of the trial, the juror asked the courtroom deputy if she could obtain an autograph from Allred. When asked by the court why she wanted an autograph, the juror responded, "Because I admire her." Just because you know other cases I've never heard, I didn't know she was going to be here. I just admire her for what she's accomplished. This was the same alternate juror who admitted during the jury selection process that she knew about allegations against defendant, and specifically that he was married to Jane Doe number 1 when she was underage. Trial counsel belatedly sought to remove the juror, stating, "I can't think of anything more disqualifying than a juror asking for the autograph of one of the attorneys who represents one of the witnesses. It speaks to a bias for the prosecution's witnesses, and for that reason, I would ask that she be removed." The request was denied. The trial counsel was, of course, correct that this juror clearly evinced a bias against defendant and in favor of his accusers. But counsel's failure to ask the court to question the jurors during Voir more extensively about her factual knowledge of defense marriage to Jane Doe number 1 and her feelings concerning allegations of sexual abuse made it impossible for the defendant to gather an accurate impression and make an educated decision about whether she was qualified to serve. Had counsel competently questioned this juror, he likely would have learned information that revealed a bias consistent with her request to obtain an autograph from Allred, a woman she admired, who called defendant the worst predator she had pursued. Defendant has demonstrated prejudice by trial counsel's failure to conduct any meaningful voir dire, where his jury was comprised largely of people who were seated with an understanding that the defendant was a sexual I'm tired of saying that word, because defendant cannot possibly prove the likelihood of success. If his case was heard by a fair and impartial jury, prejudice must be presumed. Trial counsel abdicated all responsibility to conduct a meaningful voir dire, which resulted in a jury that was largely unqualified to serve. The United States Supreme Court has recognized that in certain Sixth Amendment contexts, prejudice is presumed. Actual or constructive denial of the assistance of counsel altogether is legally presumed to result in prejudice. Strickland 466 U.S. at 692. This case is one of those rare cases. Accordingly, this court should vacate the verdicts of guilt and grant defendant a new trial. 2. Defendant is entitled to a new trial where one of his trial attorneys labored under a disabling conflict of interest as a result of her simultaneous representation of the defendant and the government star witness Jane that was imputed to the entire defense team. Defendant is entitled to a new trial where he was denied his Sixth Amendment constitutional guarantee of conflict-free counsel. Mere weeks before the commencement of trial, it was discovered that one of the defendant's attorneys, Ms. Becker, may be suffering from a conflict of interest because of her prior representation of the government's key witnesses, Jane. Consistent with its obligation, the court conducted a Coercion hearing and concluded that Ms. Becker had entered into an attorney-client relationship with Jane while she was representing the defendant. Although this conflict was an unwaivable conflict, the court permitted defendant to waive it because defendant was denied conflict-free counsel by an attorney who likely possessed information that could have been used to discredit Jane's testimony, but was unable to utilize this information without revealing attorney-client communication. Defendant was prejudiced by this conflict. The Sixth Amendment mandates that in all criminal prosecution, the accused shall enjoy the right to have the assistance of counsel for his defense. U.S. Constitution Amendment 6. This right to counsel includes a criminal defendant's right to be represented by the counsel of his choice. Lane Festa v. Artuz. citing Wheat versus United States. However, this qualified right is supported by, among other things, the Sixth Amendment right to effective assistance of counsel. A defendant's Sixth Amendment right to effective assistance of counsel includes the right to representation by conflict-free counsel, United States versus Schwartz. A per se conflict of interest exists. 1, where the attorney was not licensed to practice law because he failed to satisfy the substantive requirements of admissions to the bar, and 2, where the attorney was implicated in the defendant's crime, United States versus Luciano. The per se rule applies when an attorney is implicated in the crimes of his or her clients, since in that event, the attorney cannot be free from fear that a vigorous defense should lead the prosecutor or the trial judge to discover evidence of the attorney's own wrongdoing, United States versus Fulton. An attorney has an actual, as opposed to potential, conflict of interest when during the course of the representation, the attorney's and the defendant's interests diverge with respect to a material, factual, or legal issue or to a course of action, Schwartz. While a defendant is generally required to demonstrate prejudice to prevail on a claim of ineffective assistance of counsel, this is not so when counsel is burdened by an actual conflict of interest. Prejudice is presumed under such circumstances. In the case at bar, defendant is entitled to a new trial where his attorney labeled under a per se and or actual conflict of interest that could not be waived. At a cursory hearing held on July 15, 2021, just weeks before the commencement of trial, Jane's prior attorney, Ms. Rodriguez, disclosed to the court that she was previously retained by Jane and another possible government witness, Jay Savage, in July 2019. Rodriguez met defendant's attorney, Ms. Becker, in person at a bond hearing at the Dirksen Center in July 2019. Ms. Rodriguez expressly told Ms. Becker that she represented Jane and Savage, instructing her not to contact Jane. Ms. Rodriguez provided a text message to the court that showed that she, Rodriguez, texted Ms. Becker, stating, "I don't want the lines blurred regarding our role, and I think they're already blurred. Please do not contact them at all without my knowledge." Rodriguez told the court that she later learned that Ms. Becker had been contacting Jane and Savage. According to Rodriguez, Jane suggested that she was getting advice from Becker in connection to how to handle the media. Rodriguez declined to divulge further information about her conversations with Jane, but stated that her representation formally ended when she received an instruction signed by Jane telling her to provide her attorney's file to her new attorney, Ms. Becker. Ms. Becker confirmed that she had communications with Jane. The government also confirmed that Jane had told prosecutors that she had a lengthy meeting with Ms. Becker in August 2019. The government revealed that in their conversation with Jane revealed information to the government that she received from Ms. Becker that the government viewed as adverse to the defendant. After considering statements made by Ms. Rodriguez, the court noted that Ms. Rodriguez stated that Ms. Becker had given her clients legal advice that conflicted with the advice that Rodriguez had given her client. This court similarly concluded that Ms. Becker had formed an attorney-client relationship with Jane while she was representing the defendant, evidenced not only by Ms. Rodriguez's statements, but by the fact that Jane instructed Rodriguez to send her file to Ms. Becker. The government further pointed out that Ms. Becker might suffer from a so-called Fulton conflict, which arises when a lawyer is accused of misconduct, whether true or not. In those scenarios, the attorney may violate his or her duty of loyalty to her client by prioritizing her own interests in defending herself against accusation of misconduct, Fulton, Supra. This court acknowledged that Ms. Becker did suffer from a conflict, but that it amounted to a conflict that could be waived and mitigated by ensuring that Becker did not conduct the cross-examination of Jane. This court afforded defendant the opportunity to consult with a third-party lawyer and admonished him before accepting his waiver of conflict-free counsel. Defendant is entitled to a new trial where his attorney, Ms. Becker, labored under a per se or actual conflict of interest that could not be waived. First, as the government pointed out, Ms. Becker seemingly suffered from a Fulton conflict, a per se conflict, where there is no question that by communicating about the case with the government's key witness, notwithstanding that the witness had her own counsel and did not consent to the communications, she opened herself up to accusations of misconduct or even possibly an attempt to influence a government's witness on behalf of her client. That is not to say that the allegation is true, but an attorney who may be perceived as having engaged in that type of misconduct suffers from a per se conflict, since the attorney cannot be free from fear that a vigorous defense should lead the prosecutor or the trial judge to discover evidence of the attorney's own wrongdoing, Fulton Supra. Second, when Ms. Becker formed an attorney-client relationship with Jane, her interests diverged from the defendant because she also owed a duty of loyalty to Jane, the government's key witness. Ms. Becker was placed under inconsistent duties because of her representation of the defendant and Jane, and adverse witness. Prejudice must be presumed where Ms. Becker had at least one extended conversation with Jane about her relationship with the defendant and may have obtained privileged information from the file that Jane's prior attorney sent to Becker at Jane's request. However, Becker was prohibited by the attorney-client privilege from disclosing any information she may have received from conversations with Jane or from her prior attorney's file, even if that information would have been beneficial to the defendant's defense. Similarly, as the government suggested, although the record is unclear on this point, Jane may have obtained privileged information from Becker that was adverse to the defendant, information that most certainly was passed along to the government. Courts have recognized that where a lawyer seeks to simultaneously represent a defendant and a cooperating witness in the same criminal proceedings, a conflict of interest exists. United States versus Jane. See also United States versus Douglas. Further, whenever a defense attorney has previously represented an important government witness who testifies against his client, the possibility of a conflict of interest exists. And Voir versus United States. With these principles in mind, Ms. Becker suffered from an actual conflict of interest that could not be waived. That conflict was imputed to her trial partners, United States versus Stein. An attorney's conflict are ordinarily imputed to his firm based on the presumption that associated attorneys share clients' confidences. If Becker had merely interviewed or conversed with Jane, she would have had no duty of loyalty to Jane that conflicted with her duty of loyalty to the defendant. But as this court concluded, Becker formed an attorney-client relationship with Jane that put her at odds with her duty of loyalty to the defendant. The risk of prejudice was made more significant by the fact that Jane was not just any witness, but the government's star witness. The defendant's Sixth Amendment guarantee of a conflict-free counsel was denied. In light of the foregoing, defendant's convictions must be vacated in a new trial order. Dated February 17, 2022, New York, New York. Respectfully submitted, Jennifer Bonjean.
All right. Thank you, ladies. Thank you so much. I appreciate it. All right, so guys, what do you think?
And I get an amen.
Amen.
Well, you probably need to get that thing back, whatever you did before, because now I hear all this echo.
Okay, let me go back to it.
I didn't hear echo before.
I'm gonna mute to see if it's me.
Do you hear it now?
No,
You hear it now?
I have to mute because somebody's snoring.
Okay. Okay, I'm gonna mute. Okay, go ahead.
Is it me? Can you all hear it when I mute?
No, we don't hear the echo.
I don't hear echo.
Sylvia, I think it's you.
You sound like you way in the background, Miss Sylvia.
Hear me?
Barely.
You are very low and you have a static behind you.
That's not static, that's a snoring.
Who?
Snoring. Somebody
snoring. I think I don't hear snoring, but there is like, I don't know, like a TV. It's going.
No, it's not TV, it's a snoring, I'm telling you.
Buzzing. Buzzing is the word. Are we going to the next document?
There's no more. It's the same one.
Okay. Okay. That was a lot, you guys. Somebody said they were going in on Greenberg on Twitter. What are they saying? And is he responding? Well, we need the screenshots.
Hold on, let me show you. Okay, it says here, in R. Kelly's motion for a new trial, his lawyer argued that the singer trial attorney did little to drill down the jury selection and strike obvious biased people from the panel. They point out answers like these on juror number 3. Then Steve says the post-trial motions are epic and his trial lawyers should have been embarrassed. Did you hear me?
Yeah, I heard you. I don't know if they can
Repeat
still
that
hear
again.
me.
I'm sorry. You sound low. Repeat that again. I'm sorry. I didn't catch it.
I don't know why I sound low. I still sound low?
You sound like you're in the background or something. Well, on my end. I don't know about anybody else's end. But.
Hold on, let me see.
No, you are low. Kill the land. What Bonjean is saying is even if he chose to keep the ineffective counsel, it should not have been allowed. There was too much of a conflict for her to be allowed to have stayed on this case.
That's what I was going to ask. Yeah. Okay. Yeah. So the judge should have made that decision to remove her.
Because she had to be loyal to the defendant and the star witness that was against him. But they didn't want to postpone the trial. That's why she did that. Because that Becker and Farinella were the only ones who were senior attorneys. So if she would have had to get rid of her, they would have had to give him time to get a new attorney to catch up. Oh, Sylvia, you're so low now. We can't hear you at all. Ooh, that's crazy. Now I understand why she absolutely wanted them off the case before she turned these motions in. You think that they could have tried to prevent the filing of these motions? They were definitely part of the setup, and there's no question in my mind.
That's why they had to go.
Yeah, and there's got to be things that he can file against them in order to not only get his money back, but they should be in trouble for not doing their job.
Jocelyn says she thought the new lawyers were there when they selected the jury.
They were. I heard Sylvia say they were, but
Can y'all hear me?
barely.
I don't know why my thing is not.
Everyone, please, please, please share this. This is
Can you hear me?
good information that could help awareness for people who just don't know what's going on with this man. He was railroaded, and if regular people could see this, maybe they would change their mind about the information that they think they know. Break it up, chop and screw it, but give them this information.
Can y'all hear me now?
Good.
No.
Yeah.
I know. I'm sorry, I was cracking a joke because you sound like the Verizon commercial. Can you hear me now?
Is it low?
Yes, low.
Oh my God, what's going on here? I don't want the snoring to be heard. So
It's better than what it was.
oh, you know who's snoring.
Oh,
Better. I
Oh.
don't even hear the buzzing anymore.
I don't hear it. I don't hear anything. I just hear you.
Okay. And I'm trying not to talk loud because I'm in the room.
Oh, okay. Well, this is a mess. Oh my gosh.
So, does anybody else remember hearing different stories about the jurors, but never any of this?
I remember I told y'all about the this autograph. Remember?
I
That's
do
the only thing I
remember
heard
that.
about the autograph, but I didn't know they had, some of them had watched the series and read up on his other stuff. I didn't know any of that.
Yeah. They were saying initially that the jurors they were saying they did know him. It was a computer geek. It was people like, they kind of gave the impression like it was a white boy who, didn't listen to that type of music. They claimed they didn't know who he was.
Yeah.
That type of stuff.
Mm-hmm.
These people all said they watched this docuseries.
Yep. And read and was familiar with who he was.
And knew who he was and had opinions on him.
Yep.
Some bullshit. So I'm sorry.
Yep. And I just wonder what Azrael gave Nicole that probably could have helped Robert. But hey, they couldn't use it in court.
Probably could have helped.
Yep. Ain't no telling what was in there.
And of course she had to protect herself because her license was at stake.
Yeah. And then, since she knew that they couldn't use it in court, she just got on the stand and said whatever. They couldn't dispute it. I mean, it's in the file.
If she would have accidentally brought it up, they would have used it against her.
Mm-hmm.
So, I mean, now we understand why she got set down.
Mm-hmm.
And we can also see why the attorneys were fighting. Because just like you said, weren't the new attorneys on during all this? If Greenberg was claiming he was head and they were fighting over power, we can see why there was such a breakdown.
Mm-hmm. Instead of preparing for the trial, they up there fighting amongst each other.
Okay, there's another motion to ask for extension on motion 33.
What is motion 33?
It says the undersigned counsel defendant Rule 29 and Rule 33 motion today. I write this letter motion separately to request a leave to supplement defendant Rule 33 motion if necessary, as this court is aware that MDC suspended legal visit for almost a month due to COVID, which greatly interfered with the counsel's ability to communicate with defendant. Legal calls and Zoom meetings were unreliable and in short supply through the month of January. On February 1st, 2021, the entire BOP went on security lockdown that further prevented communication with defendant. Indeed, the MDC only resumed legal visit last week. Undersigned counsel had her first legal visit with defendant in roughly a month on February 10th. Since then, she has been able to visit with defendant by Zoom several times, which allowed her to complete defendant post-trial motion by today's due date. However, defendant has additional concern related to his trial, including issues related to prior representation that still needs to be discussed and which could possibly lead to filing a supplement in Rule 33 motion. Accordingly, undersigned counsel seeks to preserve defendant's right to supplement his motion for a new trial if necessary. Defendant respectively requests 30 days to supplement his Rule 33 motion. Oh, wow. It's more coming. You heard me?
Hello?
Y'all heard me?
Yeah.
Okay. There's more coming.
Oh, wow. But she made that comment, I'm losing my train of thought, about them playing this dirty game of trying to put different people's court dates further behind his. What I can't remember what I was watching where she said that. So if she's asking for this extension, they're going to have to move his sentencing date, right?
I don't know. Well, she's asking for a new trial, but she said there's more stuff in regards to his representation. So he got more stuff. Probably gonna put stuff about Steve in them on there too.
This stuff was about Steve too. He's included in this. While he wrote that tweet talking about not me, jury selection is on him.
Yep.
Yeah, he sucks.
Yeah, it's terrible. She is no joke. She is no joke.
She did do it all by law. She didn't really bring
exactly. What about no? He needs to get out so he can stay with his girlfriend. No foolishness. She was strictly law.
Yep.
Yeah, she didn't put any of his side of the story in any of the paperwork. She just said this was what was stated and this was what is law. So yeah, we didn't get any additional, information because that's going to have to be used if there is a retrial. That's easy. I hope she starts putting different things out in the media, though, if that ends up being the case, a retrial. The media now has to, get the other sides of the story like they did previous to this trial.
But I want to see if they tweet. Do you see him tweeting anything? I don't see them tweeting anything. She's doing her thing, boy.
Trina says she is uncovering them all. Yes, she is. Hey, Miss Trina. Hey.
She is doing her thing.
It's crazy. I'm all, Sylvia, I appreciate you. Thank you for coming out and giving us this to read to the people.
You're welcome. You're welcome.
Yes,
everybody give Sylvia her kudos.
You know they're not gonna give me kudos. They're gonna make a video about me. What's wrong that I do?
Well, everybody in the chat give Sylvia her kudos. You're here.
What those purple hearts? Purple hearts.
Hey, look! I heard there was a video done about me and my little thing I did earlier. Folks are dogging me out. Even folks with blue wrenches over here was dogging me out.
Don't even worry about it. If they talking about you.
You know I'm not, girly. You know I ain't worried about that stuff. Come on. I'm just making a joke. You know me.
Being relevant is a compliment.
They say when you've been talked about, you're doing something right.
You know me, I gotta laugh. But they in my bushes right now because I had 270 at one point.
They definitely are in your bushes because they had to get this information.
It's all right. It's all love. I got, you know what I said? I was going to read my last affirmation. You know what my last affirmation said? Hold on. Got to read my last affirmation. My last affirmation said, my trust does not lie on the truth of man. My trust lies in God alone, who fights my battle for me. Therefore, I do not fear or worry about who is against me. Amen.
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 Ooh, yeah. Ooh, child. Hey, Robbie. But God is good. God is good, y'all. I told y'all, don't worry. Don't worry. God's got this. You're welcome, Shelly. God's got this. He got this. He got this.
He's putting all the right people in their places.
Grace, thank you.
Yep. Shower that love, people. And share. And like.
Yeah.
I only see 190 likes.
Look, hey, you know they're not gonna like. Come on now.
The question was asked, what do you think the prosecution is going to come back with?
What can they come back with? She went bam, bam.
You know they're gonna come back with something, but man, it's gonna be difficult this time.
It ain't gonna be no 60-some pages.
Yeah, she did a Boston on them. You know, like, you know, when playing spade, she got the 13 books.
It's gonna be difficult this time, but they always come back with fluff. They're gonna throw out some cases. We'll see.
Because it was so mixed up on experience. Some of the stuff they were putting out, it's just that you had people on this side who wasn't doing anything, you know. That's right. She's putting out facts and law.
I don't see how they're gonna combat them using the California law that was redacted or repealed. How are they gonna combat that? It was brought up in court, and they said they were using it because it was in place when he supposedly committed the crime. But she brought up.
She has a good question. Dub K says, "What do you think going to happen to the mother?" Y'all, the details on those text messages, man.
They knew all this though, so to me, the prosecution should be in trouble for withholding. Or they didn't withhold.
The mama was the one pushing prostitution, soliciting her own daughter.
Yeah, it makes you feel a certain kind of way about Angelo. Like, did he not know? Did he not know? But the wife was with the movement.
Yeah.
Like, did he not get this paperwork? Did he not see these texts?
But look, even the juror part is going to mess them up. The juror part?
He knew because remember at the hotel said the parents sent the police there. So he knew some of them. They were all conspiring.
Man,
that man sat on Choke's live and said R. Kelly ran out the back door. But this paperwork just said they resumed what they were doing. She didn't leave. They continued.
And the police checked the identification.
Which we knew.
Genesis, there was some text messages. There was text messages mentioned. It was like, what page was that? Like,
ooh. It was like probably like 30-something, wasn't it? 20-something, 30-something.
When her mom was telling her to go, fix her hair this way and do that.
And she better act young, take off that lipstick, keep your hair curly. And obviously she was not a virgin. Because
sit on his lap, dance, sit on his lap. And
she definitely was not a virgin because her mother was trying to talk her into tooting that thing.
Yep, she probably was. What kind of mother would do that?
Exactly. I wish I would.
Is going to be older than me.
Well, you know what the thing that got me when she said, he's enspelled, like they got cast a spell on him or something.
Mm.
No videos. Trina said, nope. Government didn't have nothing. Wow, these videos.
Okay.
No video.
Yeah. I want to hear what they got to say now. Those other people kept saying, oh, those hundreds of devices had all kinds of video on it.
You know what they're going to say. They're going to say they're all in Chicago. It's going to be on the Chicago case. You said that for New York. Just wait until Chicago. Chicago probably not going to happen.
Dorothy says, Sylvia, does Art know how much you and y'all are rooting for him with these informational reading? I know he'll be grateful. Dorothy, I'm doing because it's my assignment. I got another assignment. Once this is done, I'm moving on to the next assignment. And I'm bringing Miss Prospective me and Judge over here with me.
Happily coming along.
Yeah. Man, don't the court use all them big old words, honey? I'm like, Lord, Jesus.
I was getting tongue-tied.
Tongue-tied, twisted.
And when they start naming all those cases, it was like, ooh, I'm skipping.
Oh, Lord, it makes you want to go look some of them cases up. Like,
I do want to.
Yeah,
a case for this, a case for that. I'm like,
no, there was no way those jurors should have been on there.
No. They should start all over. That's why none of them have popped up anywhere.
Yeah.
So,
the Me Too movement.
What did you guys see out of this that you can compare to the letters? Besides Greenberg being corrupt.
Called him corrupt.
He is corrupt.
I even like the way what she said about Demetrius too.
Oh yeah.
Oh, she laid everything out one by one, and stuff that we mentioned. You know what I mean?
Yeah. When you're not even given a sure answer, it's like, I don't think, that's not an answer.
She got Geronda, she got Faith. Faith.
Mm-hmm. They put in that part about Faith giving that interview. I'm not a victim. Oh no.
Hey, you heard how I read it? I was reading it with that. No.
Yeah.
Yeah, I'm
not a victim. No. It was a choice. Yeah, okay. And like she said, the government haven't even proved that he'd infected or anybody. I mean, it never was proven that he actually has it. That's what I'm tripping off of.
And I think that's why she didn't add any new stuff, because if there is a real retrial, that's the stuff she's going to have to use in the trial. Because I'm like, is she going to come out at any point in time and say he was never diagnosed? He just wasn't. So.
But you know what I like about her? She acknowledged what they said, but then she gave the law behind it.
Mm-hmm.
That's what I like. She really did good on that.
So they probably thinking, well, she just took over the case. She's not going to prepare a good motion. She hit them with facts and oh my God, when the government get it. Oh Lord.
I'm just thinking in this well thought out plan, did they not anticipate him being able to get a good appeal attorney?
They didn't expect her to come on board.
And I wonder if she's pro bono, because maybe they thought he wouldn't be able to because he doesn't have the funds.
If she put on one show, he can pay her back with no problem.
That's what I said earlier. He is going to pay her back tenfold if that's the case.
Anthony Clay said, I think the jurors was a part of the Me Too movement. That's what I said. I think they just grabbed some of them from that. Even if it wasn't the women, they got some of the spouses or something. Something's up with that juror. Oh,
well, she told it all. Leslie said it's called interweaving facts with law.
I can't wait till they respond. When they have to respond?
By the 10th of March.
Oh, okay.
So they got about 2 weeks. And then
And they're gonna wait until the last minute too.
Then she comes back. She comes back on the 24th. She ain't done with them.
Good. Sock it to them.
Yeah.
Well, hopefully we'll see what the judge says about this extension that she just filed, right? But I don't think this judge would want to deny her after everything she just pointed out.
Yeah.
Because she looking suspect too for allowing all the jurors, for allowing the lawyer to stay, for allowing the case to ride when it wasn't. I mean, all the laws that she pointed out that they, what's the word? Just like twisted to get it to come.
And I don't understand why she was just so rushed to go ahead and start the trial. I mean, my goodness, we're still in the middle of a pandemic. I mean, he got 2 new lawyers, and she could have said an extra 30, 45 days, 60 days, whatever. It wouldn't have mattered.
Mm-hmm.
But she didn't want them to be prepared to me.
Didn't she only give 2 weeks and said something about he needs to have a speedy trial?
Yeah, and then remember they said Geronda was going to have the baby, so they pushed it up a couple of more days, so he didn't get the whole full 2 weeks.
Like she couldn't have had the baby and then come.
Mm-hmm.
And whatever happened with the lady that didn't testify?
Yeah, that was wrong too. She didn't even address that.
She did not yet.
I don't even think he probably was aware of some of those lawsuits. I think they just used
Power of attorney.
Name. Power of attorney forged his name, and
it was probably Daryl McDavid.
Yeah, he probably wasn't aware of some of them lawsuits.
Did you guys see? Where was it? I don't know what I seen or whether she posted it, where she said Daryl McDavid better, tread lightly now and not, want to turn against him because of what's coming. Did you guys see that?
Yeah, I saw that. Mm-hmm.
You think they're gonna get together with his attorneys to come up with a game plan for them together?
They're gonna tear those girls up.
They're gonna have to, because they're all co-counsel. They're gonna work together to make sure all of them.
3 attorneys. It's not just one anymore.
Not one.
3.
And did Avenatti still represent any of these people?
He did represent 6 of them, remember?
He did in the beginning, but by time, like, I want to say, what's her name? Azriel Daddy dropped off of him.
Yeah, but remember what I read the other day?
I came in late to that video and I haven't gone back and watched the beginning. Is that the one where Tanya was reading?
Yeah.
I need to go back and watch it. I'm gonna watch it tomorrow morning.
Yeah, watch that one, because it gives you details of how many people he actually was representing, and he also represented the person that brought the tape too, which was Demetrius.
Which was Demetrius?
Mm-hmm.
Wow.
What about that? There was that black guy who did that interview with Gloria next to him. Who was that guy?
The one that said he had in the basement or something?
Tape. That was supposedly the other tape that they played.
Okay.
The original one that Avenatti had, that was what's name, because he said the person lived in California. In the thing we read. Remember well, you didn't listen to it. You go back and listen to it.
It was apparent that the government bullied all of them. The government bullied all of them. That's why they were all asked, did you want to be here? And they all said no.
If you're a real victim, you want to be there.
Exactly. You will want him to, justice. None of them wanted to be there.
Yeah. Yeah, I'm so glad the people that are in here are new people. They have listened to this. And in fact, I have an interview tomorrow from one of them that wants to hear about this. So
keep on doing God's work, Sylvia. Amen. You guys all share this. Share. Do you hear my excitement?
Yeah.
You see Dorothy's question?
What's Dr. Hudson? Even though I agreed for the original lawyer to stay and represent both sides, I'm sure Bonjean will state a case law that, yeah, thank you, Dorothy, invalidates the switch of the single representative.
Case law? She did.
She did in
Stand
that,
case law.
mhm.
She said Fontaine versus something. It was a conflict of interest.
Was that Fulton versus? Was that?
Yeah.
Fulton?
Yes. Fulton.
Yeah.
Fulton versus there's a Fulton versus Schwartz and Fulton.
She's thorough, like the guy
She
said.
is. Whew.
Guy said she's very, very thorough.
I didn't want to, change screens on my phone, so I haven't even gotten a chance to go and share it everywhere that I can. But as soon as we get off, because I don't want anyone to catch it in the middle now, I want them to watch it from the beginning all the way through.
Yeah.
I'm going to share this thing everywhere.
Yeah, definitely we need to share.
Right, Carolyn. Carolyn says she did state the case law and the judge tried to throw it back on Robert to make the decision when she should have made the decision. Yeah, the judge should have made that decision.
Sir Miguel, thank you, sweetie pie. That's my buddy, Sir Miguel. I like that picture Sir Miguel always have on here. Malcolm.
Disciplinary committee will get notices, maybe. They should.
I don't think that the government can take this law without, this loss. They have to go after somebody. And I say the parents.
Yep.
Mm-hmm.
I say.
What happened is if she rejects it, it's going to go to the appeal court. If she rejects
it. Somebody's going to have to pay.
Yeah.
Leslie said Nicole's opening statement was off. It sure was, especially when she said, you have to find him. That might have been her key word to the jurors. They all might have been in cahoots. I don't put nothing
cahoots with each other, yeah.
Like when I say you have to find him guilty, but oops, I'm sorry, not guilty. That might have been their little key word to say, okay.
But the jurors, man, the questionnaire, how do you keep them on there? I remember when I was watching Cardi B's case in when they were picking the jurors, they were like drilling them. So how do you keep a juror like that and not grill them the way that Cardi B's thing was grilling them? They did not play. They asked them so many questions.
Yvette said Judge Undoubtedly most likely granted an acquittal because she doesn't want her robe stained with conspiracy. Let's hope and pray that she does.
Yeah, she's going to have to do something. If not, the appellate court's going to get it.
Well, from what I hear, like when you're a judge, like what this judge is, she's not going to even get a slap on the wrist for this. It just, they don't like it.
But you don't want your stuff to go to the appellate and then get overturned.
But even if it does, what does it do to it just means that one of your things get overturned. But it's not really going to hurt her. She still gets to trial. Huh?
Yes, it would.
It don't look good.
And remember, they could request to have a different judge to do it too.
That would be good.
Miss Trina said, good night. Have a blessed night. Good night, Miss Trina.
But yeah, I'm about to go to bed.
I'm about to go too because I got to get up early in the morning.
Ladies, again, thank you. Thank you.
You're
guys.
welcome. You're welcome. You're welcome.
Thank you. Have a good night. Thank you again for providing that for all of us.
Yes, again. Thanks. Bye, family. Bye, family. I have a blessed night.
Perspective, I had to come out because the way you kept like, I need to go take a nap. If it's not for anybody else, I did it for you.
I appreciate you because, man, I got on here with slob coming down my face. I'm going to read. I was asleep.
Yeah, she's one of them that was bugging me.
Oh, okay.
I was just a little anxious.
Well, I'm glad we got to read it. I don't care how long it was, but woo,
Thank
it
you,
was
guys.
good. It was some good information.
Thank you, guys. I appreciate y'all.
Good night, everyone. See you guys tomorrow. Are we doing affirmations in the morning?
Absolutely. Absolutely.
I'll be working, but I'll be listening.
All right, honey. I'll see
All
you guys
right.
later. Good night, everybody.
Y'all, good night.
Good night.
Night.
Okay, ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Get it off of me. Get it off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?